arose out of the same incident. And
Judge, if I may, PC has been found, we don't.
It's pretty serious. I need to know bond conditions or if there's.
The complainant called in a welfare check because her boyfriend, the now defendant, beat her up and she locked herself in the bathroom. The now defendant complainant had been dating for 3 months but don't live together. Officer made contact with the complainant defendant's residence where the assault occurred and observed her have a visible black eye on her right eye, a visible bruising on her arm. She stated that the argument started because she observed another female's name on his truck's Bluetooth while they were out in front of the driveway in his truck and she asked him to take her home, but she said he waited until the morning. Now defendant got upset and threw a beer and at her instructor on the head with his hand and her head and it hit her inside a car. She put SOS on her phone to call 911, but then the defendant took her phone and told them it was an accidental call. She was then locked inside the defendant's home, where inside she was pushed, forcibly grabbed, and had her hair pulled by the defendant. Officers observed a clump of her hair on the defendant's bedroom floor, and the defendant poked her in the right eye, which caused new bruising and swelling to her eye. The defendant then turned on the location services on her phone, preventing her loved ones from tracking her. The complainant was able to get 911 help by secretly texting family and friends who found her location by driving to the location she was being held at. She had older injuries when she stated she had been caused by a defendant in the past 3 months, and she didn't report it because she was scared and nervous. She stated to the officers that on June 23rd, 26th at defense residence, he grabbed her, causing bruising, pulling her hair and slamming her phone against her hand that caused 2 of her nails to break. She stated also on June 18, 2026 on Washington Avenue within the confines of Harris County. Defendant and her were walking and he pushed her down to the sidewalk, causing both of her knees to be scraped. Officers observed stabbing to both of her knees consistent with the assault. The complainant confirmed she feared for her life during these assaults and did feel pain.
Where was the unlawful restraint though?
It was at the residence, Judge.
Did you say that he held her there?
That one was, yes, one moment, Judge. She was locked inside the home. Inside the home, she was pushed, forcibly grabbed and her hair pulled. Let me go back to the original summary. She was unable to leave because she was locked in. Sorry, I'm reading this out of order. Complainant was locked inside the gate fence and locked inside the home of the defendant. She was unable to leave because she was locked in.
Mr. Sanchez, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to consume alcohol or illegal drugs, and you will be randomly tested. I'm ordering you not to have any contact with this complaining witness and not to go where she lives or where she works. Do you understand? If you violate these conditions, if you try to attempt any contact, and I don't care if she initiates it with you, if you have contact with this person, I will revoke your bond, put you in jail. There'll be no more PR bonds for you. You understand? If I have to put you in jail, I'm going to deem you a public danger and I'm going to make your bond high. I will protect my community at all costs. You understand me? You are not to be in possession of any weapons as well. I'll have him, he'll be monitored by pretrial, so you guys don't need to file anything at the moment.
Yes, sir.
So we'll have you sign a reset. We'll have you meet with pretrial here momentarily, and after that, you guys are good to go.
Thank you, Judge.
Okay, thanks. Please. Thank you. Yeah.
Okay.
All right, Judge, next is page 1. Britton, come on up. Sanchez, Britton, yeah.
Is Cynthia Shaw here?
I'll check on it, Judge.
We're waiting for her to start the hearing.
Page 1, Judge.
Okay.
Britton.
Good morning, Mr. Britton. So you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On June 30th, 2026, in Harris County, Texas, at 10:15 at night, officers on patrol noticed a car on a public roadway with a defective left rear taillight cover that was broken, and it had a white light emitting to the rear. Officers of the traffic cop and the defendant provided a driver's license that was not eligible and had no insurance. And then the officers saw that the defendant's his license was suspended for no liability insurance that began on February 3rd of 2026.
Got it.
And then the insurance database was unconfirmed.
Mr. Britton, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you are ordered not to drive. I don't care what you have to do in this life. There's nothing that you can justify getting into a car and driving. I don't care that you have to work. I don't care that you need groceries. I don't care that a baby has to go to the hospital. You will be signing an affidavit with me today promising me you're not going to drive. If you do, I can have a contempt hearing, and every time up to 180 days in jail and a $500 fine. You drive 5 times, I can have 5 contempt hearings. Do you understand? If you want to drive, go get a license, Texas driver license and liability insurance, show it to us and then we can talk. But until that point, you drive, it's going to go really poorly. Do you understand me? We're going to reset your case to give you time to hire a lawyer. I'm going to have you come up here, swear to us that you're not going to drive, and we're going to get you out of here. When you come back, please have a lawyer.
All right, Judge
Okay.
Fleischer. Page 4.
You're Mr. Fleischer. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On July 1st, 2026, in Harris County, Texas, the officer dispatched to a traffic hazard on the public roadway. The officer arrived, the defendant asleep in the driver's seat while the car was running. An officer knocked and woke the defendant. He started to drive on the sidewalk. The wheel witness said that he noticed the car and saw the defendant asleep with the car running. The defendant stated he was on the way home from the feet fan test and was waiting on his friend because he didn't want to drink and drive. Defendant stated he had 2 drinks. The officer also noticed bloodshot eyes, alcohol, an odor of alcohol from the breath. The odor of alcohol beverage from the breath, I'm sorry. Then the SFSDs were 6 out of 6 on the HGM, 1 out of 8 on the Washington, and 0 out of 4 on the one night stand. And the DSC was red, and then he consented to a blood draw.
Okay. Does he have any prior DWIs?
He has no criminal.
Can you see if he has a license to drive or?
Status, okay, that one.
Yeah. Do you have the ability to look, Mr. Kim, can you help me out? Mr. Kim, I know she's flanked by people over there. Can you, this is Mr. Fleischer. Can you run to see if he has a license to drive, please? Mr. Fleischer, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol or illegal drugs. You will be randomly tested, including marijuana. If you test positive, I will revoke your bond and put you in jail. Do you understand? You're not allowed to drive unless you have a valid Texas driver license and liability insurance. You must maintain both. If you don't have it, then likewise, do not drive. That is also a condition of your bond. How old are you, sir? How do you support yourself? Are you working at this time? So you say you're in school or you're not in school? Where do you go to school? Are you enrolled full-time, part-time, 2 hours? What are you doing? Okay. You need more to do with your time. When you have too much time on your hands, people tend to become self-destructive. You need to be either working full-time or in school full-time. Do you understand? All right. Deputy, do you mind giving him an application for an appointed lawyer, please? I'm going to give you an application. I need to know everything about you, how much money you have coming in, who you live with, what kind of cars you have, and then we'll see whether you qualify for a court-appointed lawyer. I don't know who you have in the slash, Mr. Fisher, but if I have to revoke your bond and put you in jail, this is not going to be PR bond after PR bond. Do you understand? Okay, come on.
Johnson. Page 10.
How many more, Lori?
Yeah, I'll do 2 more, Judge.
This is Johnson, you say?
Page 10.
So what's the first name?
It starts with a D. D, yeah. Mr. Johnson, you have already missed court once. Your case is 160 days old. We set cases for trial at 180 days. It would probably behoove you quick to find a lawyer because at the next setting, we are going to set your case for trial. You understand? We are going to reset you 30 days. When you come back, be ready. As a condition of your bond, you were ordered not to consume alcohol or illegal drugs. You will be randomly tested. If you do not have a valid Texas driver license, then you are not allowed to drive. That is also a condition of your bond. Do you understand? Mr. Kim, do you mind checking on Mr. Johnson here? If he has a valid license to drive?
Yes. It's valid until 2032.
Until when?
Until 2030. Oh, actually, no, I'm sorry, no, it just got lifted. Until 2032, he has a valid license.
It is that you're showing it's eligible?
Yes.
Okay. All right, sir, we're gonna have you sign a reset. You will meet eventually with pre-file for your bond conditions, and then we'll see you in 30 days. Come on.
All right, Judge, next.
No drugs, no alcohol,
24,
random UAs.
Sorzano. Sorry, Judge, use the Spanish speaker.
Okay,
The next one is. Oh, that's it, then, Judge.
wonderful. Okay,
Go ahead and sign for your reset.
Ms. Shaw, are you ready?
Yes. Yeah, that's fine.
Guys, we're currently in trial. We're about to start back up. If you need to use your phone, if you need to talk, please go outside. We will be on the record. Guys, we will have a DA back there be able to talk to you. Sorry, but we're in the middle of trial and
What time do you anticipate breaking?
probably about 45 minutes. Yeah, we're just gonna do a hearing real quick on a motion to suppress, and after that, we'll take a break, and then after that, we'll begin. We'll do court business and then we'll start the trial. Good morning, Mr. Hackett.
We're gonna take ours to chambers back here. Chambers back on the back. We're gonna take the chambers.
Yeah, sure, of course. God, in one day, I got, did you see how many bond violations came up in one damn day? Did you see that? What the? I mean, really? Ramona, you're here? Okay.
Yes, ma'am.
Ready?
Yes.
Michelle, you ready?
Thanks.
Oh, um, Shanae, let me check real quick. Hold on.
Thank you, Judge.
Did you see, she's right here today?
Yeah, she just.
She's here. Okay, you guys ready?
Yes, John.
You ready?
Yes,
So I guess you want to take this witness now, presumably.
yes, please.
What is the witness's name?
I
What
don't
is-
know, we never know which tech suit they're sending, I don't know who they are.
Miss Cotter. Miss Cotter.
Uh,
Laura.
Lauren Cotter.
Okay, do you mind grabbing that witness, please?
Yeah. She's in one of the minutes, please.
Thank you, Deputy.
We're in trial, you'll have to go to the back.
Man, the DAs are in back. We're in the middle of trial.
They'll still let you come in.
That's okay. We're going to start at suppression real quick. All right, coming up, ma'am. If you please raise your right. Oh, we're back on the record in our trial case, State of Texas versus Jaime Cruz. If you please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, come up. If you please would speak loudly, clearly. If you hear the word objection, please just stop talking until we've addressed it, and at that point, we may continue. Okay? All right.
May I?
Yep.
Good morning.
Good morning.
Would you mind just stating your name, so we have it on the record?
Yes, it's Lauren Cotter, spelled Lauren, Kotter.
Okay. And obviously you work for DPS as a whatever other things you might do, but you're here in the capacity of threat test technical supervisor, right?
Yes, that's correct.
Okay. And you also, you maintain, aren't you like the custodian of records of breath test operator certificates?
Yes. That's correct.
Okay, and so you would know if Deputy Perez from Precinct 4 is a certified breath test operator?
Yes, I could look that up.
Have you, if you haven't yet, can you look that up and tell us whether he is or not?
Yes, I could. I have not.
Do you have something to look it up with?
I have my phone.
Can you look it up on your phone? I mean, I can give you my iPad if you want to look it up on there,
So I can use my phone.
or, okay. Or do you already know if he is or not?
No, I do not know.
Okay, if you wouldn't mind checking that, I'd appreciate it.
Do you have the operator certification number?
I don't think he's certified at all, so that's,
Oh, okay.
there
Well,
wouldn't be. Well, the operator was Don Varner. The Deputy Perez was the one that was in the room. You know what, it actually doesn't matter for this hearing, but you should, yeah, it actually doesn't matter. So let me, sorry. Let me move ahead, did you talk to the state at all in preparing for this case?
no.
Okay. You know that according to the Texas Administrative Code, there's a statute, a law that requires a 15-minute abstinence or observation period, right?
Yes, there is.
Of the subject, right?
Yes.
A full 15 minutes before he would give a breath specimen, right?
Yes, that's correct.
And according to Don Varner and what I've heard you guys say, correct me if I'm wrong, but the purpose of that is to make sure they don't put anything in their mouth, right?
Yes, correct.
And they're not supposed to touch their face, right?
It doesn't say that they can't touch their face, but they are not supposed to put anything into their mouth.
Okay. Burping, vomiting, right?
Yes.
We don't have any vomiting in this case, but those are the things that, that you're saying, and also that Don Varner, do you know Don Varner?
Yes,
Okay. And so those are the things that you're supposed to guard against is, burping is one of them, right?
yes, that's one of the things to look out for during the 15-minute waiting period.
Okay. And the reason or the concern is that you don't want any, like residual mouth alcohol to affect the breath test, right?
Yes, that's correct.
And you regurgitate, burp, put something in your mouth, that could falsely elevate the VAC, right?
It could.
Okay. If the subject burps in that 15 minutes, what would be the procedure to follow?
Typically, you would want to restart the 15-minute waiting period.
Okay. I'm not gonna ask you if there's a valid test in this case because I've asked that so many times and I know the answer. And if it prints out a slip, you say it's valid. But that doesn't mean that all the proper procedures were followed before it printed out a breath test slip. Right?
Potentially.
I mean, there's nothing or no indicator on there of anything that happened or could have happened during the 15-minute observation period, right?
Not specifically.
Okay. So we got to rely on humans to make that observation. As a matter of fact, the law requires a certified or an operator. I don't think it says certified, but it has to be a certified breath test operator that conducts that observation period, right?
Yes, that's correct.
Okay. Even if you had an officer watch for 7 minutes and then the breath test operator comes in, watches for the rest 8 minutes, if the officer is not a certified breath test operator, that can't count in the 15-minute observation period, right?
That's correct.
But multiple certified breath test operators could combine, correct?
Yes, you could.
Okay. I'll pass the witness. Well, I'm sorry, Nick. Yeah, it's just, well,
Are you sure? You'll have a chance to redirect as well if you want. I mean,
Are you aware of the administrative code statute number?
I'm sorry, that's you.
Are you aware of the administrative code section that contains the requirement of the observation period
I believe it's Title 37, Chapter 19.
of the administrative code?
Correct.
Okay. I have that one somewhere. Okay, I'll pass it to
okay.
So, you're, in this particular case, you know, who watched, the defendant during the observation period, correct?
I do not.
And you don't know what time, they got there.
No, I do not.
In fact, you're here to testify mainly about the maintenance of the machine that was used and not about the procedures or how the test was done that day.
I can only testify to what I know and what I'm an expert in.
I have no question.
I will pass the witness, so just like her to.
Yeah, subject to recall.
So to recall.
Sure. Okay, ma'am, you may step down. Thank you so much for your testimony.
Oh, I'd like to call Jaime Cruz. But just for the purposes of this hearing, and I'd like to limit the scope to actions that occurred during the 15-minute observation period, not discovery opportunity to ask about all other kinds of things.
I subject to cross.
Well, a relevant subject, everybody's got a different thought about the rules of evidence and how they apply to motion to suppress. like even Margaret Harris agreed, let's try to follow them anyway. So I don't know how you feel about that, but I would object to.
That's a first for me. In this respect, so I guess go and we'll see how it plays out.
Oh, sorry, go ahead. Yeah, Ms. Kraski actually did wanted to do the talking, so.
So limiting the scope of cross-examination for a defendant in to just a singular suppression issue is something that is a right by the Fifth Amendment privilege against self-incrimination. This has been litigated in Texas courts and the Court of Criminal Appeals. We have Davis v. State, which upholds this, Ramirez v. State, which also upholds this, that the testimony be limited to just what the issue is in suppression, and not go beyond that scope. And so anything that would go beyond the scope of what is happening during this observation period would be a violation of the Fifth Amendment and would be reversible error if allowed to go into different testimony regarding things that are not at issue in the suppression hearing.
I can't hear you.
Excuse me. They can object should they feel the need at the time where questions are coming up.
Sure. I mean, I do what you need to do. Just raise an objection, make a legal objection. Don't just say object, make the objection, and then we'll address it as it comes. I don't know what all will be, what you guys are going to get into yet, so we'll see. We'll just take it up in due course, you know?
That's why.
Well, yeah, so the subject of this, the suppression motion is the observation period specifically. So that's the something that we're getting into for the motion to suppress.
Do you want to call another witness now, or do you want to rest?
Well,
You want to call?
Just for the record, I'm not sure why we're calling Deputy Combs Donna.
No. No. This Bruce. His client. We're talking about his client.
Deputy Alan, Perez.
Yeah, you're talking about your client, right?
yes.
Yeah.
Mr. Cruz next. And yet yesterday I said I don't have any intention of calling Varner or Perez. But that's up to say, obviously, if they want to.
Sure. Okay. Yeah. Once he rests in at that point, you can, wherever you want. Okay. Mr. Flood, are you ready?
Yes, so I'd like to call Jaime Cruz.
All right, coming up.
And it's on the record that I was jokingly calling him Ignacio. For the record, that is not real. That's not his real name, and that's a joke.
Yeah, I mean, right.
I don't want it to.
All right. Please raise your right hand.
Referring to him as, sorry.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes.
All right, come, please take a seat. As I've said with everybody else, please speak low, slowly, loudly, clearly. If you hear the word objection, just stop. Once we've addressed it, at that point, you may continue.
Okay.
Okay.
No, we got number 3.
Yes, yes.
I'm gonna mark this as demonstrative and then fill it out. Mr. Cruz, I just want to ask you a few questions about what you remember from like the breath test room. Okay. Okay, you remember being in there? Yes, sir. And oh. For the purposes of this hearing, I'd like to move to admit defense exhibit 4 and send it to opposing counsel. It's just a copy of the slip in this case. Just for the purposes of this hearing. Defendant's exhibit 4.
Do you have any objection?
No objection.
Okay, it'll be admitted as demonstrative.
I want it in as evidence for this
Yeah,
hearing.
okay. All right, it'll
Is
be
the
admitted.
elbow working? We're not gonna mess with that.
Oh, yeah.
I don't really need to. I can just show it to the judge. We have other copies. Do you mind if I approach and,
I've seen 1,000.
okay. Mr. Ignacio, were you aware of this? I missed you. Mr. Cruz, I'm sorry, I've got one, so. Ignacio is not any part of your name, right? Nobody calls you that, it's not your middle name or any part of your name. You remember what time that you, blew in this case?
I do not.
Your Honor, we have admitted defense exhibit 2 yesterday. I think it was just for the purposes of the hearing. I'd like to show the portion of the 15-minute observation period that's in question.
Do you know, have you seen what he's going to show?
It's the JVC video unredacted.
It is the JPC video, Judge, but it is, that the observation period is not there. So if counsel is trying to say that that was an observation period, that is just the video of the testing.
It shows observation period.
Okay, well, we'll see. I don't know.
Specifically, what I intend to show is, at 4 minutes on the video, about 4 minutes on the media player. And then, so it's a defense exhibit 2 JPC video, showing Deputy Perez, Mr. Cruz, and then Don Varner, who was the breath test operator. So I'm gonna start it, there's an event that's about 4 minutes and another event, and then he blows on here at 7:31 on the media player. I'm gonna write those times down. So it's like 4 minutes after these happened, then he blows. And the breathless operator didn't catch it, didn't observe.
7:31 for purposes of the video, because the breath test stuff
Right.
says 5:30.
Just on the media player time.
Okay.
Right, but it's okay, because if we go by the media player time, you can see how much time was elapsed. Okay. Can you see that okay? So do you remember what happened during that period?
A little bit, but yes.
Okay. And what are we about to see?
For now, probably just sitting down, but probably.
Well, I'll go ahead and play it, and then I'll ask you what you did, okay? Able to see that? Yes. Okay. I'm gonna just rewind it just a couple seconds. Can you tell me what? If you watch again, tell me what happened. What was that?
No, that was a bird.
a burp. We didn't hear you cough. You didn't make like a loud burping sound. Nobody turned their head, and so it was a quiet burp. Yes, sir. I mean, just drinking soda during trial, you can, and you look like, did you see like your body's building up something and you kind of like lean over a picture?
Yes, sir.
Would that be like how you would typically?
Of course, because he was quiet in the room, so I don't want to burp it out.
Okay. And then after this, were you ready to put your fingers in your mouth?
Maybe because I'm nervous. For this.
Well, that was my next question. Is that something, why? You said because you're nervous. Is that something that you would commonly do in a nervous situation?
Obviously, yes.
Bite your nails or? Okay. Okay. Actually, I'm gonna pause right there because, so that verb was. Okay, so like, we'll put 4:05 on the immediate player sign. Back it up for a second, and I'm putting MP down here to signify immediate player time. And then that was the first blow, right? Okay, so that says 4:51 on the immediate player time. I think it's after your first blow, then you put your fingers in your mouth, is that right? Actually, okay, I think it's at 7:10, so I'm gonna move this forward just a little bit. Try to start it, I'm gonna start at 7. Oh. Starting at 6:54 on the immediate time.
Did you mean 4?
Sorry.
Did you mean 4 or 6?
I have it down to the 7:10 on the media player time. When he was.
Oh, okay.
So it's kind of hard to see, but. So I don't know if you see it, it's kind of hard to tell for sure, but what were you doing right there? I mean, part of the time it looks like you're just kind of holding your chin. Oh, I'm saying I was just one. But right there, see that? What were you doing?
I guess I was just holding my chin like this.
But is that where you put your, okay. Do you see anything where it shows you put your fingers in your mouth or chewing on your nails?
Maybe after 2 seconds.
Okay, so this is right where you're saying.
So can you stop there
Yes, John.
and ask the question?
Yes, sir. Did you hear what I said?
No.
Oh. You saw you put your hands.
Objection, leading.
Oh. That's it. What did you witness that you did with your hands with respect to?
Well, first, I grabbed my chin. And a few seconds, like 1, 2, then I started biting my nails.
You start biting it off. And then this is the second blow. 7:31 on the media player time. Okay, that's what.
No, all these events happened about over a year ago, correct?
Correct.
And from the time that you were arrested to the time that to JPC, do you remember how long it took
Let you get to the,
to that location?
I don't remember.
Okay. Do you remember when you got to the station, from the time that you got to the station till the time that you took this test, how long it took?
No, I don't.
Okay, so. So,
You can use it too. Where do you want to show?
it's that you already have evidence.
Okay, because you have it on disk.
I can go over this first, so I'll show it.
Okay, which is touchscreen, just. Don't have to read it. The body.
Before you get to this room, you got to the station first, right?
Yes,
And you were in a separate room before this.
right.
And you were with somebody who was observed.
No.
So you were in another room all by yourself. Nobody was there.
Well, before I got there, I was still in practice.
Correct. But while you were there, somebody else was with you. Because you were at this station for about 30 minutes at least before you got there, right?
Yes, well, I don't think I was in another room. I went directly to them.
Or were you alone the whole time?
No, I was already still,
Tell me what,
I was checking in or whatever, my fingerprints and all that.
here, you were saying that you were putting your hand in your mouth, but when we watch it here, I want you to watch closely. Right, I'm touching your face, correct?
Right, it should.
And your chin, correct? And at this point, right here, you can see your hands, your fingers curled up with your thumb here. So there is no fingers inside your mouth, correct?
Well,
If
it
you,
should be my thumb.
your thumb, as you can see, is on the side of your face. Isn't it?
Markings.
Do you want to come closer if you want to? Yeah. In fact, your mouth is not even open at the whole time. It's not correct.
I can't.
Sorry, to interrupt, you had asked me if you want to look, do you mind if the witness steps down and takes a look at the judge?
Sure.
As you see, mouth is closed. You don't see at any point.
I'm sorry,
your mouth is closed there and you don't see, if you see your mouth opening at any point there, I would like you to point it out to me. You're touching your chin there, right?
Make sure the court order social security.
But as you can see, your mouth is closed there. You are touching around your mouth. But your mouth is closed the whole time. As soon as you turn around your face, you can see your mouth being closed. Is that not true?
I don't remember, but I guess I was putting my lips like my finger.
Yeah, but I mean, I know you don't remember, but you can see right here, right? I can go back. You can see that the mouth is closed. Right? No further questions.
Okay,
Did you say you passed?
I wanted to,
do you have any more questions for this witness? Okay,
yes, Judge, I'll pass.
okay,
You said you passed?
Yes.
Okay, I will pass Williams.
Passman, okay, you may take your seat back, please.
And defense rests.
Okay, defense rest, do you have any witnesses that you'd like to call?
Yes, Judge. I'm going to call, Donald Warren extension.
Okay, please.
Bar over the English. Bar.
Warren, what did I say? I
Warner.
said Warren.
Okay, sorry.
Right. I still have an accent.
No, I know, I just, obviously.
Thank you.
No, that's, that can be listened to, so speech, society.
Come on up, Mr. Varner. Be so kind to raise your right hand, please. Do you solemnly swear to tell the truth? Oh, I think you've been sworn already.
Yes.
Come on up.
Yes.
All right, this witness has previously been sworn. Are you ready? Mr. Flood? I'm sorry. I'm thinking. Ms. Shaw, your witness.
Mr. Warner, do you remember so we have a threat test exam, that. Can I get that?
Sure.
She wants to.
Do you need the slip? I have the slip right here.
You just pull it, the USB.
Yes.
Oh, sorry.
Thank you.
Yeah.
Give you a copy of, Defense Exhibit 4. You recognize this?
Yes.
So, this is the test that you took the other, that night on, May 25, May 24, 2025, correct?
Yes.
I'm gonna play this video for you, of the testing, but before that, I wanted to ask you a couple of questions. Whenever defendants come to JPC, do they go straight to the testing room?
No.
Okay, can you walk us through the process of how you guys conduct the breath test?
The officer was signing in as far as what they needed. They needed breath, they would sign in the defendant's name, birthday, the officer's last name, case number, and they needed breath. Always check to see if they have a valid driver's license or ID, just confirm. Be bad routing sometimes. And, after that, go to the subject just to make sure, just verify they don't have anything in their mouth and just let them know that, no, but don't touch your face, don't put your hands near your mouth. And wait for 15 minutes on your timer on the clock on our phones. Proceed from there.
So do you conduct that 15-minute observation period in the testing room?
Sometimes you can, sometimes you can't.
What, the times that you can't, why is that?
Unfortunately, DWIs in Harris County where we don't have enough room to conduct the test. So once a room comes available, we'll go in and room is free.
Okay, so when that happens, where do you guys observe the defendants or the accused for the observation period?
In the open area, right outside the door, the intox room.
And is that recorded?
Yes,
There is recording of them outside?
the whole building's recorded, yes.
Okay, so why is it not provided to the state, those recordings?
The only thing I can think of is there's multiple people involved for their privacy in their case. So it's not open to the public.
So they observe multiple people at the same time for the 15-minute period.
Who is served multiple people?
So you're saying that sometimes people are observed for the 15-minute period outside the room?
Yes,
Okay. And the reason that we are not having that video is that multiple people are observed at the same time.
yes,
Is
or
that
for blood tests or other stuff, yes,
for the purpose of breath test, correct?
correct.
So, if somebody was to, if I showed you this video and the 15-minute observation period was not here and only the testing is here, would that surprise you? Would that be uncommon?
No,
Do you remember in this case, if the observation period was done here in this room or outside?
outside.
I'm gonna play the video for you and I want you to walk us through the testing and the process that you did. So any of these, is that part of your observation period?
Yes,
But it's not part of the 15-minute, correct?
it is part of the 2 minutes.
Manager,
Of course,
Mr. Varner, you're not a peace officer, right? You're like a civilian evidence technician?
Yes,
Okay. And you do breath test, smoke test, field sobriety test?
yes,
And so as we've met before, right, we're involved a lot in this.
yes,
We know that the 15-minute observation period, it is up to the first blow,
yes,
right? 15 minutes before that, that's the time we're talking about, right?
yes,
And, okay, and so you had a meeting, you talked to the prosecutors, right? And they asked you some questions and,
yes.
and I think they asked you like, what's the purpose of the 15-minute observation period?
Yes.
Right? And you agree with me that it's to check to make sure the defendant does not vomit, right?
Yes,
Put anything in his mouth, right?
yes,
Burp,
yes,
right? Okay. And I think you said you didn't observe anything. But, I don't know, you know that if a person burps, it doesn't always make a sound. There can be inaudible burps, right?
yes.
Okay. So I'm gonna just show this part right here that shows Mr. Cruz burping, okay? And I want you to watch if you're like looking at him when he does that. So did you see that? And that's, I'm stopping at 4:07 on the media clip. Did you see Mr. Cruz lean over and put his hand in front of his mouth?
Yes.
And did you notice that you were looking at the first, but then when that happened, you were looking at the screen here the whole time?
Yes.
And answer this if you know, but, there's not supposed to be any radios in the room, right?
You're correct. Yes, no radios.
Cell phones too,
Yes, no cell phone.
and officers' radio, you're not supposed to be on and with them, right?
Or just turned off.
Turned off. And I know there's a safeguard in the breath test machine that if it detects radio frequency interference, it can give an error message, right?
Yes,
That's only if it detects it, right?
yes,
Okay. But regardless, I mean, the rules of thumb and the technical supervisor say no radios, right?
yes.
All right. I don't know if did you notice that Deputy Perez is actually actively on his phone during the blows?
Yes,
You are aware of that?
yes,
And in part of it, you can even see a screen like lit up and he's using it, right?
yes,
Okay. And you didn't ensure that he took off his radio or turned it off?
assured that he has his radio off.
You're sure he had his radio off? Okay. All right, and you said they're not supposed to touch their face, right?
Yes,
And they're not supposed to put their hands, I didn't know what you said. Did you say towards their mouth or in their mouth or what?
on their mouth.
On them. Okay. And okay. And so yesterday evening or today or any time, did you talk to the prosecutors about, hey, we need to watch, or did they ask you to watch this 15-minute observation period?
Not the last couple of days.
Okay, so you didn't watch it overnight or before right now, like yesterday or today?
No,
Okay. All right, I'll pass it over.
One further question,
No? Okay. May this witness step down?
yes,
Yes, sir.
Okay. Thank you, Mr. Varner. Appreciate it. You are subject to recall, so don't
Yes,
leave, please. Okay, thanks. Do you have any further witnesses?
no, just,
Okay, so you rest.
yes.
Okay,
That's right.
all right, great. Let's do argument.
Okay. So Judge, I'm alleging and moving to suppress this breath test as it's in violation of 37 Texas Administration Code, section 19.3, which is statutory that the 15-minute observation period is required, or else it would be an illegal breath test if if there's an event that occurs, like Mr. Varner said, that he's trying to guard against, the proper procedure is to start the 15-minute observation period over. Obviously, you can be in somebody's presence, and I imagine that's what the state is gonna argue, but things can still happen that you might not notice, as we see right there. Looking at it over and over and over on our part, we realize it's not a cough, you don't hear a cough, but obviously you see something like building up and then he turns over, and I think it's pretty darn convincing that it is what Mr. Cruz said, that he burped. But then you also have at approximately 7:10 on the media player that he is putting his hands on his face, which Don Varner said they're not supposed to do that either. Those are the things that we want to guard against. And also, don't put your hands, and he didn't say it in your mouth, he said, don't put your hands on your mouth. And that happened as well. Mr. Cruz testified he was actually biting his nails. That's judgment call. We don't, it's hard to tell for sure. But the so we go by the timing, but the 15-minute observation period, I'm not even, well, I mean, that's another issue that the state brought up, that there is no proof that or video, he said there's video everywhere. And he said there's no proof that the complete 15-minute observation period had been done. I know he testified to that, but there is not 15 minutes that goes by on this video. There's only 4 minutes, 51 seconds. And but that, I'm not really arguing that point, but I think they're right that there's a lack of evidence to meet their burden here. But on the media player time, we see at 4:05 on the media player that Mr. Cruz burps, and then he blows his first blow at 4:51 on the media player time, second blow at 7:31. So there's only 46 seconds basically that go by from an event that they're supposed to be guarding against in the 15-minute observation period. That could cause residual mouth alcohol, and as the technical supervisor said, can falsely elevate the breath test. So I don't think this breath test is reliable based on the testimony that we've heard, and we're moving to suppress that.
Okay.
Well, Judge, as far as the 15-minute observation period goes, the witness testified and counsel admitted that they did have a 15-minute observation period. It doesn't have to be on camera. There's no case law that says it has to be on camera. They were at the station for 30 minutes. There are people there to watch them for 15 minutes before they get into the testing rooms, and they don't have enough testing rooms to watch everybody in the testing room with the video. So that's number one. Number two, there's gonna be a dispute if that was a burp or something else, or a cough, or whatever. But let's say if it was, case law says that it does not invalidate the result of the test. What it does, if they missed it or they didn't see it, it's minor deviations, and it will go to the weight of the evidence and not to its admissibility. The concern being, if there was.
You have a case that says a burp will not invalidate the test?
So. Yes, Judge. It says in, I have it. I'll print it out.
You can, I mean,
but it's-
finish your argument and then while you can get it to me.
I'll give you
Sure.
a copy.
Okay,
It basically says, it demonstrated that even when the record is unclear as to whether a defendant burped or regurgitated during the observation period, the Court of Appeals found that the officer sufficiently complied with the legal requirement and used reasonable care. So I'll print a copy of that. But if, and with the putting the hand around or inside the mouth, again, that's in dispute because even the defendant couldn't point out where there was a hand put inside the mouth. The concern is that it would affect the blood alcohol level to show higher than it is. But the first blow for the defendant was 0.135. That's right before allegedly he burped or put his hand in his mouth. But the second blow is 0.139. So if it was to elevate his blood alcohol level or affect it in a way that would be affecting him negatively, it should have shown on the first blow and not the second one. So all of that said, any minor deviation that might have been happening during that time, which is we allege that it's not the observation period. It goes to the weight of the evidence and not to its admissibility. I'll print out that.
okay.
Do you want me to respond? Yeah.
Is that right, what she just said?
No. There's case law.
No. The fact, I think what the point that she made just now was that he blows first.
He doesn't, that's not true, and that's why I went through this timeline.
The burp that you, because you're saying, what you just said is that he blows, then he burps, and then he blows again. And then the second blow is lower than the first.
From what I saw, he burped first, he blew, he sat down, he was touching his face, and then he blew again.
Can you replay it so we can just see
Sure.
that? Right?
Regardless, the argument that, I mean, if there's an incident that they're guarding against, it's they could falsely elevate. The breath test is gonna obviously affect the first one and the second one, if there's mouth alcohol, because there hasn't been 15 minutes.
Your point is that it just,
So I'm gonna start at 4 minutes even. And this is before his first. Well, maybe if I could here.
no. So he hasn't blown yet. Okay, all right. No, we're good. We're good. And then from the time that that happens to when he blows is what, 50 seconds? Right? 51 seconds? Okay. I think we're good.
So there's burping incident at around 4:05, and then it gets up to blow. I put 4:51 because I did that when you can hear the sound indicate that's when your breath has started, not just when you put up, and that comes out to be 46 seconds.
Okay, I think we're good. You can cut it. All right, give me a couple minutes to look at the case and then I'll make a decision. And then let's take a recess so we can help the lawyers out so we can get them out because they've been waiting for a while. And
Do you
then,
mind if I give you a site to it?
yeah, can you, what is it?
It's a Westlaw site. Is that-
Okay, sure.
Oh, I'm sorry. It's, okay, it's Smithy, Smithy v. State. And that is 850 Southwest Second, 204 from 1993. It's 850 Southwest Second, 204. And it's Smithy v. State. There's also, I know we're talking about unpublished opinions. I think they can be persuasive to consider it, don't consider it, but there is another case, Garcia v. State, where the suppression argument was, the issue was, it was denied, but it's distinguished because there was absolutely no audio or visual evidence that supported the claim that there was a burden. Obviously, we have that here.
Got it. Okay. All right, I guess you guys look at the things and then let me help the lawyers out so we can get them out and then I'll give you like 1 minute afterwards, off the record. Okay, you ready? Thanks. Hey.
Judge, it's the Frazier, we sent this morning.
Is this a new case? A different one from what you had earlier?
It's a different one.
Okay.
I believe recently we've been with the state judge, the paperwork. However, he has to say now, he would have to do any customer if he did. I spoke to the state of the oath, objection to for reset for sentencing. Asking the court.
What is he offering? It's 200 days old. I mean, how long do you want?
That's why I asked.
Why don't we do this? Why don't we do the plea and then I'll let him pick a turn-in day?
That's what I.
Yeah, I'm okay with that.
Okay.
Yeah, I mean, not 30 days, but maybe a couple weeks. I'm okay with, yeah, I'm down. Yeah, but you also need to do an admonishment though. You also have to do an admonishment because this is,
Well, I didn't know if you were gonna.
oh, the other ones are two,
Should be first.
it is the first. Okay, I
Right,
didn't
and
realize.
so
it. Okay.
if you just gave him reporting instructions, as long as that's.
Yes, we'll give them, yeah, write it up. We're good. Hi.
Okay. I'm approaching on Mr. Roberts Clay.
Is he here?
Yes, he's.
Is that him over there?
That is,
Okay. I see another BVR just got filed too. Did you see that?
that is correct, Your Honor. I got the email on that yesterday.
Ball's in your court.
Okay, Judge, so, taking the BDR issues and putting those aside for just a moment, we did reset last time, Mr. Roberts Clay to do the TRAS. He has done the TRAS and, we have that, the TRAS, is recommending several things, one of which is IOP, SOP, also BIPP, and that he be placed on the mental health caseload. The issue is this, Judge, if I may boil it down, is that he would like the opportunity to stay on and extend his current deferred from 13 months to the full 2-year term. He would like an opportunity to successfully complete that. What motivation does he have for that? He's got several months in jail that he already spent on this case while it was pending. So in theory, whatever offer the state would come up with, you pretty much have credit for whatever we do. He would really like the opportunity to show this court that he can successfully.
But he can't stay out of trouble while on bond. This is a third bond violation, man.
Well, so Judge, all the BVRs are based on a scram and tamper. And in June, there were allegations of a scram tamper, and he was called into pretrial. Both times he went, both times he's telling them, look, I'm not doing anything to this device. This is what he represents to me now with the same thing.
But it continues to happen. We now have a tamper at 3:24 in the morning and there's a detection of alcohol. It continues to happen.
I do understand that, Judge, but perhaps IOP, SOP would be something that could help him address this issue.
He's on bond for an assault, picks up a harassment,
On the
can't
first.
stop. I mean, yeah, right, he's on deferred
Yes, sir.
for the, picks up a harassment. All these are the same complaining witness, correct?
It is correct, Judge, yes.
Just come up, Mr. Roberts Clay. You know, I can only give someone the benefit of doubt so many times. At some point, if I continue, then I become the enabler. And then I tell you, it's okay to continue have bond violation. You're on deferred for a case where it was a screaming heart deal. I mean, you had what, 1, 2, 3, 4, 5, 6, 7 cases. All those get kicked for a deferred on an assault. While on deferred, you pick up harassment, and now it's your third bond violation. No, you're going to jail. I cannot continue to, at some point.
Judge, as an alternative, would the court consider our proposal of allowing him to attempt to complete the deferred adjudication and the court assessing days in jail as a condition that essentially he has 2 options, Judge. He can plead to.
I'm okay with that. I'm okay with that. I mean, what state would say you?
Well, I would disagree that it's an incentive because it's for the bond revocation that he's already here for.
No, he's now.
Well, that's what I mean. It's not incentive to complete it down the line, especially with 3 violations already here with the new law violation. It doesn't say anything about the future. It's just what's about the present. So I would disagree. However, I understand.
You know what I would venture a guess though, is that there are more underlying issues.
I don't
And
disagree, Judge.
I would guess that the next step is inpatient treatment, because now I don't know why they haven't done it now, maybe to give him the opportunity, but the next step is another violation. I will have you TRAS'd again. My feeling is the next one, you'll be looking at inpatient treatment. I can always alter an amend to put you in it. You'll be sitting at least 2 months waiting for a bed, and then you sit there for another 9 months to a year and a half going through treatment in the jail. Now, I have nothing left at my disposal but jail. Do you understand? If you test positive again, you may very well sit in a treatment program for at least 9 months to a year and a half. Do you understand? I have gone over this with you over and over, and like a little child, I am up to here. It's done. Yes,
So you're gonna want a second TRAS for him?
not now.
Oh, okay. Yes.
Because we've already done one now,
Okay.
but in the event that and so as part of it though, if we do it, because it has to continue with this grant. So I know that he's monitored 24/7, so I know. And what do you think's reasonable as far as days as a condition?
Well, I mean, that's only half of it because for the new.
To add some context, the Judge, I don't believe this is the prosecutor we were dealing with last time. Last time when we reset the case, Ms. Nakfi and I were discussing the case.
She's there.
Oh, yeah.
So,
she knows.
yeah,
what's
you
going on
guys
with the case.
have at it and then let me know.
Okay, thank
So
you.
you talk and see, I don't know, maybe there's a global resolution today. If not, just, yeah. Council, come on up. Come on up. Hi, good morning.
This is a case from Austin County, Austin Travis County. It was transferred to Harris County 3 days ago. And it states, according to the client, that we had to come to court within 7 days of his release. He's out of bond. All I'm here today for is to get a court date. We have the.
Do you have a cause number?
Yes, Judge.
Okay, what is it?
5253
Okay,
8595.
did you get it?
Yes, Your Honor.
What do you mean it's from Travis County? I don't,
He was a warrant out and he got picked up in Travis.
did he post an out of county bond?
Yes, Judge.
He does? Okay,
Not Harris County. Austin.
He posted it in Austin.
Yes, Judge.
Okay, do you mind bringing him up, please? Aquara, come up. Good morning, sir. So you're charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On October 1st, 2024, complainant came into the Houston Police Department station to speak with the officer. Complainant stated that on July 31st, 2024, defendant came to complainant's apartment. Defendant was asking for his stuff, and complainant told him he could not come inside and that a witness would come and grab his stuff. The witness gave defendant's property. Defendant said his game system was missing. Defendant pushed the door open with his foot, forcing his way past complainant. Complainant grabbed defendant's shirt and told him he could not come inside. Defendant backhanded complainant's arms and walked towards witness's room. Complainant stood in front of witness's bedroom and blocked the way. Defendant then attacked complainant by punching her multiple times, striking her in the head, chest, and legs. Defendant also threatened to kill complainant. Witness and a friend got in between defendant and stopped this. Complainant felt pain and sustained bruises and broke his fingernails.
Got it. Okay, sir, I'm going to find that there's sufficient probable cause to go forward with your case as a condition of your bond. You were ordered not to have any contact with the complaining witness in this case, not to go where they live or work, and not to be in possession of any weapons. If you violate this condition, I will order your arrest, put you in jail. There'll be no more PR bonds for you. Do you understand? Okay, so he has posted bond or he has not posted bonds?
He posted a bond in Travis County. He posted a bond.
You can confirm.
Yes.
Okay, great. So so what we will do now, I need you, if you don't mind, file an attorney record so that we can attach you to the case. We will give you a reset. I'm going to need you to take a seat. Do not leave until you have bond conditions signed. They're going to file them now. We'll call you up here in about 30 minutes. Once you sign them, at that point, you'll be free to go. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with her. If she tells me she cannot get a hold of you, then I'm going to revoke your bond. Do not pick up any new cases. Do you understand? I don't care what's going on in your life. We'll protect my community at all costs. You endanger it. It's just not going to go well between us. Do you understand? Okay. We'll have you sign the documents and then after that, you'll be free to go. Thank you, counsel. Just please remember the attorney of record, okay? Okay. Hi, Elon. Great to see you, man. It's been way too long. Okay.
There may be two on this.
Yeah, your case is old. Where are we headed?
Yeah, I subbed in about halfway through.
Okay.
PTI application today.
You're turning in the application today? All right. Our chief is in trial now. Let's set it a week just because it's so old.
They're gonna get more time.
Well, we have a division chief, so it should be just, yeah. If it's approved, then we'll need him here to send it for a TRAS. If there's no decision, then it'll be waived. Yeah, okay, thanks a lot. Hi, come on up. Good morning.
Judge, I'm here for Mr. Carrabos Sierra.
Okay, do you mind bringing him up?
Your Honor, that's actually what I wanted to address, Judge. Magistrate gave him a PR bond. He's not a U.S. citizen, so he has been
Okay, so how do you know that?
So his wife is here, he kind of indicates to me that she's been in contact with him.
Is he in ICE custody now?
Correct, Your Honor.
Do you have proof of that?
I do not have proof, Judge. I do know where he is located.
So you should be able to go to the website. Is it DHS or who is it? There's a certain way using the A number to get that he's actually in detention now. If he is, and you can show it to me today, we'll give you a reset for whatever day you want and just keep us in the loop and we'll reset you. If he gets right at that point, I'll end up revoking because there's really nothing we can do. But just before you leave today, show me that he's in and then we'll just give you a date, whatever you want. Yeah, okay. Guerra.
Mr. Guerra.
He's saying that he's in ICE detention. Once he got a PR bond, they took him.
Sorry, John or Gerard, there's two.
No. And it looks like it shows that he was released to immigration only, so it looks like they did, but just out of an abundance of caution, show it to us and then we'll give you the reason. Okay, thanks. Mr. Saldana,
Morning, Judge, how are you?
wow, way too long. How are you, man?
I'm good, Judge.
What's up?
I have Mr. Giovanni Ramirez on docket.
Jail or bond?
It's all on your honor.
Okay, where are we headed?
Potentially a trial, Your Honor, but there are some issues on when Judge Jackson was covering on May 20th. She signed a bring motion for me. I'm still waiting on discovery on that. And she told me,
It's nearly 200 days and you're waiting on something? What are you waiting on?
this is an interesting issue. She told me to revisit probable cause when you were here because it's under 1403D. It's a Deer Park officer who arrested my guy in Pasadena and he never communicated with Pasadena at all. So he was outside of jurisdiction and he actually didn't follow the rules under 1403.
I don't have time to do it now. I've got a jury waiting. We need to bring him in.
Okay.
So, but regardless, you're still missing discovery. We're at 200 days. Not cool. I'm going to give them a 10-day discovery hearing. If they don't have it to you, then whatever's not here is just not here. What are you waiting on?
I want the officers MDTs and the GPS track on this patrol.
And have you asked for it?
Yes, specifically in the motion that she signed, yes, Your Honor.
Okay.
I'm making.
So let's do this. I'll set you for a 10-day discovery hearing from today. Whatever's not in at that point is just,
Understood. And.
in the interim, if you want to come back maybe Monday
That's fine.
or maybe Tuesday, it'll be less died down, probably Tuesday, and then we can do another probable cause hearing if you want.
Perfect.
But be ready for any kind of case law that you need as far as
Understood.
whatever your argument is.
Does my client need to be here on that day?
No, I mean,
He
no.
is here because I don't want.
I understand. Don't worry about it. I'll waive it for that one because, but usually because it's so old, we require me to come here. But because we have a plan, I'll waive it for that hearing. But get with them to let them know that it's a 10-day discovery hearing. Okay, thanks.
Thanks, Aaron.
Bye, Aaron. Counsel, come on up.
Briefly, Your Honor, just a motion to restore property order that's been queued up on a dismissed case this morning.
Okay, do you have proof that, what, are you getting a gun? Okay, do you have proof that it's actually their gun?
The defendant's gun?
Correct.
No.
I've given a gun back and it was given to the wrong person and I don't want to do that again. It was a really big ordeal. So
Let me.
Yeah.
Attach something as an
if
exhibit.
you can get some kind of proof, usually you'll get some kind of receipt, says the serial number, the name, as long as you have that and they're unopposed.
Well, right, because there's 4 different factors, and so I want to know what the offense and history, there's a lot of different qualifiers, so I want to know and have the opportunity to hear.
Sure. So set it for like a week and then let's come back and just be ready. Yeah, sure thing. Mr. Washington, what's up?
Sounds like you're in trial.
Yep.
Walk through it, need to, would you better come back?
Later. I can't, I got to bring the jury in. They've been waiting so long, really, over and over and over.
I'm just gonna take a quarter to make sure we have enough trucks for you.
Sure. Okay. Hey, Ms. Reingold, come on up. Or let's do your plea. Good morning, Mrs. Wong.
Good morning.
Yeah, I mean, don't worry about it. Hold on. I'll just get it. Yeah. It's on Uloa. All right. Good morning, Mr. Uloa.
Good morning.
Sir, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement where they're offering you 27 days in jail with credit for the 9 days that you have done. You were giving up the right to a trial, right to compel witnesses to testify on your behalf, front and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, deny naturalization, and give up the right to appeal. Once you accept this agreement, you can never change this or undo this. You understand?
Yes, I do, Your Honor.
Is this what you want to do?
Yes, Your Honor.
How do you plead to the offense of unlawful carrying of a weapon?
Yes,
Understand that I don't know you. If you're on probation or parole, this can be used to revoke that, resulting in further confinement.
yes,
Knowing this, do you still want to go forward?
yes, sir.
Okay. About the weapons, are they being forfeited? Yeah, I mean, I'm gonna forfeit.
Okay.
Let me see. Yeah, he's got a felony. It's not, will not get the weapons back. History law. All right, I'm gonna find you guilty. I will follow. I'm going to follow the agreement. I will send it to it. It looks like one of them is going to be dismissed,
Yes,
the 2162.
yes, sir.
Okay, all right. Good luck to you, sir.
Thank you so much, Judge.
You got it, man. Take care.
Yes, sir. Sorry about the wait.
Oh, come on. Who's next? Ms. Reingold, come on up.
I have, Burke's my document, the BDR.
What's the last name?
Burke's, BURKS.
Burks, come up. What is the nature of the bond violation? I don't remember.
Unapproved been entered for just 15 minutes. She has a curfew attached to one of the monitoring devices at the base station in the home. She reports to me, she stepped out to the porch.
Okay.
Very short.
No means no. Doesn't mean I gotta go take the trash out. I gotta go. No means no. Do you understand? You are on notice now. Any further violations, it may not go well between us. You understand me, Ms. Burks? Bond conditions are bond conditions and you cannot violate them for any reason. There's no justification that you can give. I don't know why you're looking at me like I'm speaking in a different language, man. Do you understand? It's no tolerance going forward. Okay, thank you. Any further violations? All right, thank you. Just take a seat, ma'am. All right, come on up.
Judge, I visited with Ms. Knockby about my client's situation, and she stated that she would agree to 5 days as a condition. My client recently obtained a job at a car wash, and this would allow us to keep that job and continue to work.
Show me proof, but I'm not going to take his word for it. But I think 5 days is just,
What does the court have in mind?
I don't know, but
He's been on probation since April of 2025. He has been reporting, but he hasn't completed any of his classes. And he's tested positive at least 4 times for marijuana.
just does what he wants to do. He doesn't care. That's why are we performing an exercise in futility? You know what I mean?
I definitely
He's shown-
understand, but
he's shown-
his position is that rather than in some regards, take the easy route and take a time served on free food, rather continue.
Whoa, assuming we would accept.
Well, then the reason I say that, Judge, is that he has several months credit in jail. That's why I'm saying it's up to a year. So the sheriff is obviously going to give a 3-4 credit. But I mean, that's why I'm saying that he would like the opportunity to be extended to the full term, do some days in jail, and continue to be under the court supervision.
All right, 20 days, okay, we'll acquiesce, but I'm not doing any further long. He's gonna have to come here, show us that he's actually performing, and let's give him, so he starts VIP now, right?
Yes.
One of the conditions is VIP. Are you dismissing the new case?
Taking a look right now, Your Honor.
That's what we discussed last.
So we will alter and amend, add VIP as a condition,
Yes.
and
Court
today's,
consider 15 days, Judge?
sure.
Thank you, Judge.
So 15 days from today. He must be enrolled in the BIP class by August 3rd. Okay? If not, a new motion will be filed and then we'll just go there and then he's got to come here, bring proof. That's 2 weeks after the day that he should be released. There should be plenty of time to enroll. And then we're going to micromanage because nothing has worked so far. If another motion is filed, tell him. Okay,
Understood, Your Honor. Thank you,
okay,
Judge.
you got
15 days starting today.
it today. Yeah, all right. Eddie, ready?
Yes. For the future case.
Did you get it?
We found the passport. It's here with me now.
Okay, if you just want to tender to them, I'll make a docket notation on Dinesh, so passport tendered to clerk, set bond at $6,000. Okay, man, you got it. Have fun.
Thank you.
Ms. Kuhn, coming up.
Morning, Your Honor.
Hi, good morning.
I'm here filling in for my colleague Scott. Mr. Rodriguez is on docket today.
Lucas?
Rodriguez.
Rodriguez. Jail or
7,
He's in custody.
47, you say?
47, 739 days.
Okay.
Which is why I'm approaching.
Oh, we-
Scott has asked me to roll one more day because he's. but
I'm okay with that. Don't worry about it.
All right, that's all. That's
Yeah.
what I was going to do.
Hey, serenity now. Could be worse. I know she couldn't, she said she could be here. You want to do Monday?
I think so. I suggested Monday. I feel that. Monday.
Yay or nay? What, you care, I don't, whatever, I don't care. You guys, get out. Okay, Mitch, watch.
We would go with this, just the interpreter, it's just probably not, so we'll come later about noon.
Yeah, we'll be here. Yeah, council, coming up.
Your Honor, she was fine here, may I approach?
Yeah, come on. Do you want to see this too?
No, I just saw.
You saw? Okay, let's do 30 days. Are you going to represent him in ICE detention too?
No, Your Honor, I'm not too sure what he's gonna do. He may actually self-deploy.
Okay, we'd like you, I guess, just give us a heads up if it does, and then in 30 days, we'll see. Yeah, okay.
This will be required appearance or appearance.
Only event that they lift, I mean, they release.
Yeah, I mean, right. If he gets somehow get an immigration bond or gets released, he's got to be here. So let's do required. Guerra Flores. Guerra Flores?
Yes.
Flores Guerra? Yeah, okay. Come on.
Hey. Mr. Robin Fraser, this we talked about earlier.
Are you ready?
I'm ready.
Okay, Fraser, coming up.
One or 2 weeks ago.
Yeah, for sure.
Okay.
All right, good morning, Mr. Fraser. Sir, you're charged with indecent exposure. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 30 days in jail with credit for the 7 days that you've done. You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers if you're not a citizen. There are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this. You need to be very careful. This will go on your record. You're now facing at least a minimum of 30 days. Not only that, a second conviction on this may require Chapter 62 reporting. Do you understand? You need to be very careful, all right? Knowing all this, do you want to go through with this plea agreement? How do you plead to the offense, sir? I'm going to find you guilty. If you're on probation or parole, pleading guilty to this may result in further confinement. Do you understand? All right, good luck to you, sir. We'll roll your court costs so you won't know anything. Okay, thanks. Oh, to turn in, you get the turn in?
Yes.
So
722.
Council for recap?
to turn in 7:22 by 6 p.m. Okay.
Thank you.
All right. Anybody else? Or hold your peace because I'm bringing a jury in. So bring it. Anyone?
I told the state, there were 2 other cases I emailed you and the state.
Okay. Let's talk. Come on.
Judge, they're off docket, but maybe really quick and important.
What do you want?
Okay, so one of them, I just got onto the case.
Okay.
He had a cruise like for Friday. His bond conditions don't stop him from going international, but he has random drug testing. So that's not.
This is a problem if they're going on cruises because what happens when you go on a cruise?
I understand.
Right.
If you can get tested right before he leaves, when he gets back,
I don't know, man.
Proof that he scheduled this before he picked up this case.
That makes no difference to me. What's your cause number? Let's not put the cart ahead of the horse.
259-3071.
Yeah, And so what we'll do is we'll give him a portable device. Well, the portable device is not gonna work. I don't know what to tell you, man.
When is your honor be taking a break? I can approach.
No, my concern is that I don't want him to drink, and freezers are notorious for drinking. So I don't know, man.
If it wasn't a crash, we wouldn't be opposed, but if it crashed into a leasing office, we're gonna be opposed.
Can you say it again?
It's a crash WI where it collided into a leasing office of the complex, we're gonna be opposed.
Oof. The only way is if he puts a scram on. It's the only way.
I can talk to him.
So that way I know that he's not, but
Okay,
what's your other one?
just a little more, 254-6020. This one is set for Friday,
Oh, she's got,
but she got a new, ink monitor yesterday. So apparently it was messed up. It wasn't charging. So she got a new ink monitor yesterday.
they haven't been able to reach her. She's not been checking in. The device has been dead.
I can talk to people, but she went yesterday. She got a new ink monitor.
Yeah, check with them, let's see if she's in compliance. Stacy.
So, she did report yesterday, and when she spoke to the officers, the notes say defendant did not want device inspected and reported no issues. She said that
She did not want the device inspected?
Yes. And she did have a charger, but she left it at home, so we did not inspect the charger.
Okay, she's got to be here tomorrow. She's got to be here.
She's up on Friday. Friday,
Or that's what I meant, Friday. I
can I
meant
do
Friday.
tomorrow though? Because Friday I have a doctor's appointment. I need to be at.
Sure.
Thank you, Judge.
Hey, Stacy. Hi,
I'm here on Mr.
hurry.
Bashan,
Run, Forrest.
Bashan Isaiah Humphrey, who's in custody. Criminal trespass.
Is it under Humphrey?
Yes.
I feel like we've talked about this before, have we
Yes,
not?
he was the one that was at the Star of Hope, but ended up treated in BVR.
What should we do with Mr. Humphrey?
So the oldest case, I think it's 262 days old.
Okay,
I spoke with, the state. But not been able to resolve this case in the office. So,
you want to roll it maybe till Tuesday to give them just a little bit of time, and then hopefully we can work out some. I mean, he's young, I don't, really.
Yeah, there's a homelessness issue.
Yeah, I mean, I don't want to. What's he doing? Where's he gonna go? I mean, he
He's
doesn't
probably
have,
gonna go back to the Star of Hope.
but he doesn't have anyone else that'll,
My parents.
friends, family, aunt,
Yeah, he was like a
uncle.
lady friend, but
She,
she doesn't have housing.
okay. We're in the middle of trial now. Maybe you can reach out to Farwell, see if they'll get it done quicker.
Okay.
We have a ton of cases on for Friday, so, I mean, okay.
I only have one other thing, it's off docket, but,
Tell me, what's the cause number?
261,
Okay,
2376, Kenyon West. He was just here with his mom and his new, treatment coordinator.
how'd it go?
It went well. They talked to you a little bit about it.
I remember.
Trying to amend his bond conditions such that the drug testing that he's getting in San Marcos can count, but the drug testing is supposed to get here. We talked to you about it, but his bond conditions weren't amended that day.
Okay,
Because we're mainly addressing his, device issue.
okay, I'm okay with that. Yeah, and just waive the signature if you need it. Yeah, okay, Stacy.
Thank you.
Have a great day. I thought I saw Chisholm. Okay, I guess not.
And just, he did send the drug test yesterday.
Stacy. Rob, you mean with us?
He would,
When is the last time he's taken a test over
I think it
there?
was yesterday.
Are you sure?
Well,
Because they need to get us proof that they're taking a test. Otherwise, it's
Yeah, he emailed me yesterday, July 7th, Mr. Joseph Kraus, who was in court, and he
but
said,
does he have proof that,
you want him to send the actual?
Yeah,
and-
yeah.
Just
Yeah.
send me an email without asking.
that's, I mean, anyone could say, hey, I passed the test. No. Yeah.
I'll ask you.
So let's set it to next week so we make sure it gets done. So we'll give them until, Tuesday to get us the results. Okay?
All right, thank you.
Okay. If not, then a BVR gets filed and then, so please stay on and make sure that it gets done. We don't want to have to drag him over here.
No. All right, thank you.
Okay, thank you, Stacy. You re, hey, you gave me Rathode. No? Or was he, did you give me Rathode?
Yes.
We emailed you through please.
Hey, Ramona.
How's, the 23rd? I'm gonna give the details to the,
You don't why only. Give it assistance. You don't have to. It's not. See how
Six, 7, 9, and 7. Judge, Spanish ring from earlier.
Okay, is this with Washington?
No. But this one was the one on the
Well, we don't have an interpret. Oh, Luis, all right, come on, real quick.
bottom of 24. Giordano, come on.
That's a Watson. Watson.
Oh, Watson.
That's a little.
Does he have a Watson?
That's the one that's on.
Oh, that is, okay, all right.
because it's different.
Yeah, but don't send him down yet.
Yeah.
Okay, all right. Oh, hey. what's up?
Giordano,
So-
24.
All right, good morning, Mrs. Sororzano. You're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On June 3rd, 2026, in Harris County, Texas, officer was on patrol when he noted a vehicle change lanes without signaling. Officer conducted a traffic stop, and as the defendant handed his license to the officer, he noticed a handgun in the compartment on the side of the center console with a loaded magazine.
So you're saying it was in plain view? Is that what you just said?
Yes, Your Honor, the officer observed it, in a compartment on the side of the center console with the loaded magazine on top of the center.
Okay. Does he have a license to drive?
Right here right now, Your Honor.
Please. Mr. Sorzano, I'm going to find that there is probable cause to go forward with your case. As a condition of your bond, you were ordered not to be in possession of any weapons whatsoever. Otherwise, I will revoke your bond and put you in jail. I don't know what your immigration status is, but if you are not in this country with permission and you go to jail and immigration finds you, they may very well put a detainer on you. You understand? Okay,
This license is eligible.
okay. We will have bond conditions created for you to sign. Do not leave until you sign them. We will reset your case to give you time to hire a lawyer. Go ahead, we'll have you sign and then we'll get you out of here, sir. Do not leave until you sign the bond conditions. You have Marcus Young. Young? Okay. You are Mr. Young. You're charged with 2 cases, harassment and resisting arrest. On the harassment, you're facing up to 6 months in jail and or a $2,000 fine. On the resisting, you're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement. They're offering you 60 days in jail with credit for the 29 days that you've done on both cases. You are giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. If you are on probation or parole, pleading guilty to these cases may result in further confinement. Do you understand this? Knowing this, do you still want to plead guilty? All right, how do you plead? I will find you guilty on both cases, send it you to it. We will roll your court costs so you won't owe anything. Good luck to you, Mr. Young. Thank you, counsel.
The other AFM case is being dismissed.
Oh, okay. I didn't know that, but all right. Your other case will be dismissed on motion of the state. Okay. Yeah, of course. I understand. I'm always okay with you being here. They need to be here. All right, lawyers, call.
Judge, I don't know if you want to hear anything else. We've had time to read those cases.
Okay, but I don't want you to go on a huge diatribe. I think I've already made up my mind, but is she here?
Mr. Rasky was just going to say that the case they gave is obviously was going to.
Where's Miss Shaw? Is she here? No? Yeah, please.
Yeah.
All right. Talk to me. Come on, Al. Bring it.
2586
Okay,
343.
okay,
Mr. Johnson.
okay.
Mr. Johnson has maintained solid attendance with him.
Wait, there's a warrant for his arrest.
Yes, I think what happened was he had just his first bit class. If the warrant was issued for his arrest, he needed to come in and provide proof when he had been attending.
I'm not, where is he here now? Come up, sir.
He came here voluntarily, called our office, invited me all over.
Okay, so, I will reinstate the bond now, but I'm not doing any further long resets. So we need to figure out what we're doing like today.
Sean, he's been going.
No. Unless he's done with the class, I'm not doing any more further resets. I'm not doing another 18-week reset for good stuff to get done. He's been MIA for 2 months. I'll reinstate your bond now, but we need to figure out where your case is going.
Yes, sir.
So, stop, no, it doesn't, no. Just take a seat. I'm reinstating your bond, but I'm not doing any further resets. We need to figure out where this case is going. Your case is 9 months old. We set cases for trial at 180 days. Do you understand? Please take a seat. Do not leave. Did you get the cause number? Perfect. Okay, bond reinstated. Ms. Shaw, come on up. Hey. Oh, do you need something else?
You want me to roll Mr. JV on back into tomorrow?
Do you have a plan?
We want it tomorrow.
Do it today.
Yeah, we can do it today. if you want.
I
Yeah,
think you're in trials.
yeah, write it up and we'll try to get it done. Yeah.
Yeah.
Sorry, on Ricardo there.
Okay.
On docket judge, at 172 days, so I'll just told to approach. State's made an offer for probation judge, but I just wanted to go through discovery to give my client a
Okay,
chance.
well, I'll give you a week.
That's fine.
Okay,
Thank you.
he's got to be here. Is he here now?
Yes.
Okay, we'll give you a week. You ready? Ready? Come on up. Come on. Or Ms. Brasky, are you doing it? Okay, your motion, you go first.
Judge, we're back on the record.
Guys, we are going back on the record. Do not talk. If you need to talk, please go outside. Thank you.
Okay. So to respond to the case that was presented to us by the state, Rothos v. State, it looks like the issue in that case was actually just regarding if an officer has to actually observe and watch the subject the entire time. But what it also says is that in that case, the appellant burped twice and the officer actually did restart the waiting period out of an abundance of caution. And so, you know, that's what should have happened in this case after Mr. Cruz did burp before the first blow. And then afterwards, after the first blow, he had put his fingers in his mouth and was biting his nails. With the cases that we provided to the state and to the court, we have the Smithy v. State case, where the conviction was reversed because the defendant had something in his mouth and he also belched during the observation period. The expert testimony indicated that, you know, having a foreign object in the mouth, additionally belching would result in a test that could not be valid. What we heard from our expert, or what we heard from the state's expert, is that whenever these things happen, it can make a result higher improperly. And then we also provided Garcia v. State, unpublished case. And we provided this case because the facts, we have here with Mr. Cruz are distinguishable from Garcia. In Garcia, the suppression argument was based on, an alleged burp that happened, but there was no audio or visual evidence to support this claim. And there was no evidence that supported that there was a burp that actually occurred. What is different with this case with Mr. Cruz is that he had testified that he burped, he had testified that he had his fingers in his mouth. And we could see it on the video as well, which was provided, both the formation of a burp and what happened, and then also with him putting his hands on his face and in his mouth. And so for that, we would be moving to suppress the drug test results and anything that comes after.
Okay. State.
Sorry, and then Scott. This Levy court case is really about jury charge error. It's also from 1993, where
If I may, 88 Wiley, for the state WILE.
Thanks for coming and helping out.
I appreciate it. I haven't had the pleasure of practicing in front of your honor. I've looked over the cases defense counsel's provided. To start with, Judge, they provided the Smithy case and the Rafford case, at least that's how I'm gonna pronounce it, but, or we provided Rafford, they provided Smithy. Rafford and Smithy are both non-published opinions, and most are persuasive. They're both from, well, Rafford is from Dallas and Smithy is from Fort Worth. They're from the same area. But of note, Judge, that Smithy was published, or well, wasn't published, but it was written in 1993, whereas Rafford was written in 2024. I'm sure they had in front of them the Smithy case when they were writing that opinion. I won't go so far as to speculate as to why they didn't publish the Rafford opinion. But in terms of which one would appear more relevant to the case, I think Rafford stands out as the forefront, Judge. And in there, at the end of the day, the court decided that it was a use of discretion that they were looking at it under the standard being. There they found the court didn't abuse their discretion regarding letting in the test after observing what appeared to be a burp. And then opposing counsel provided Garcia v. State. Now, this is also unpublished, but it is from our county, Judge. It appears to be almost analogous with our facts. I know opposing counsel put forward to the court that there's clearly a burp seen on camera. I don't know if that is the case, Judge. That's something for your honor to decide, not necessarily them. You've seen the video. From what we saw, we had some testimony from the defendant himself getting on the stand talking about how he wasn't even sure if his mouth was open. He had to be pointed to that fact multiple times. So in weighing whether or not there was actually a burp, and I'm sure your honor saw, he was led through the entirety of that direct.
But out of an abundance of caution, how easy is it to do another 15-minute observation period?
I'm sure it would have been very easy, Judge, and should those have been the facts, I think this would be a much easier decision. I think opposing counsel has raised the motion to suppress for a reason, but I think here it just falls short of what would be required to actually suppress this evidence.
Yeah.
It's just that the observation period was done before they got in the room, and of course, it would have been great if they had noticed what appeared to be a verb if there, or if it was. And they had restarted the time, but as you can see, he was trying to set up the machine and he didn't even look his way and didn't see it.
So
again,
do they
if
get
it-
penalized because of it? You
Well,
know?
no, Judge, but it's just.
And why is the observation period not on video too?
Well, there was testimony as to why they just don't have enough rooms to put every single defendant to be videoed and.
With the
it's
advent of
not-
technology now, you can blur faces so that, you know, any other privacy issues, we have no clue who it would be.
Yes, Judge,
But I mean,
that's-
really,
But that's not required, for them to be on video for the result of the test to be admitted into evidence. Counsel can for sure bring it up on cross and allow the jury to give the evidence the way it deserves or the way that they think it deserves. But to suppress it completely just based on that, I don't.
okay, you ready? All right, I'm gonna grant your motion. All right. I'm gonna give you back this case law. So where do we go from here now?
Discuss, Judge.
Yeah, okay.
Mr. Flood, was this just a verbal motion to suppress?
Well, I think we filed a generic motion to suppress, but it didn't specify this.
Right.
And I can, if
So
you want
it's
to print it out, I can just write on it.
Okay, we'll do that one and judge it right.
Yeah.
Judge, can you get a few minutes?
Yeah, take 5 minutes, for sure.
Last name Okor, I mean, last name starts with an O. Oh. Brian O. No, you can come on this stuff. I'm just gonna get you to sign your bond condition. On the keypad whenever you're ready. And I'm just gonna give you a copy. The lady in the middle, say you just allow you away. Okay.
After this,
There you go. You're welcome. Have a good day.
Hi, Max, come on up. It's fine. We're
Extraordinary circumstances.
just tell me what's up.
Jury duty about.
Oh, nice. Good. Who you got?
I've got Mr. Miguel Garcia.
Garcia. Okay, where are we at?
So.
It was restitution, right?
Yes, so this is the case we talked about last week.
Yeah.
We're doing restitution dismiss on $1,500 You wanted us to take a look and see if there's a possibility for the PD's office to do something along the lines of an alternate account. I did check with our holistic division, that's not something I was able to do.
Okay.
But I did talk to Mr. Garcia to see if he could like come up with some kind of way for us to monitor and keep track of his savings to get to that 1,500. I think we have a possible compromise. If he's gotten up to 650 right now, has it in a cash app account that he is able to keep track of, send me updates to the balance of that. My hope was that if maybe we could,
So he's got half now.
he's, getting close to having it. 650, I don't know.
Okay.
If the court would be willing for us to reset the case and waive his appearance, I can be here and give the court an update as far as how he's doing and progressing to that.
How long do you want?
If the court wants a quick update, we can do.
No. Where's Mr. Garcia now? Come up, sir. So
At this rate, I think he could probably get it in a month.
that's, would be the hope, because we're now at 180 days. So how long will it take you to come up with the remainder, Mr. Garcia?
What are we on today?
Today is the July 8th.
By the end of the month. Of this month.
Are you sure? Are you really sure? I want to give you enough time, but at the same time, we at some point have to put these cases to bed and we just can't reset. It just, okay, so pick a day, the first week of August. That is the final date. If it's not done and paid for and dismissed by that date, is there an alternate offer that you have? I'm not doing any more resets after that time.
No, this offer of restitution we discussed has only been on the table since last month.
Sure. Yeah.
What the court's done.
I understand, but I don't want it to drag it in 250 and then 300 because our cases are blowing at it.
We have the tax rate for an offer.
Okay, so we will give you to the first week of August. By that time, you must have it paid off and the case dismissed. If not, you must accept either an alternate resolution or I will set your case for trial. This is the last reset. Do you understand? Okay, all right. Good luck, guys.
I'm making some new people for Robert. Are you on make it or those days it will?
Yeah, something under dragon.
Okay.
Regarding the client that with the cruise, the DWI, as long as he gets, if he comes tomorrow to get the scan, it's okay to go.
Sure. Yeah. Are you guys ready?
Yes, sir.
Then I think, Officer Perez, we got as far as we could with him before
Okay.
the motion. So, you can be excused.
Okay,
The two, technicians, I guess they can be excused.
yeah, okay,
And, be permitted to close.
okay. So what we'll do is we'll bring him in, rest. Okay, and at that point, I'll ask to see if they have any witnesses and then we'll go from there. And then if they rest, do you have any witnesses?
We're gonna rest.
You're gonna rest? Okay, so at that point, we'll just get the charge ready and then we'll do closings. Do the charge and closings. Yeah?
Before we get into it, can we have, a little bit of time just to.
But they've been sitting there since 9:45. I mean, it's already now 11, nearly 11:30, like 2 minutes, right? But yeah, all right. So I'm going to bring him in at 11:30. Okay? Okay. So guys, please, at 11:30, if you don't mind bringing the jury in. Okay? It's okay. Don't worry about it. So really, they're going to be in and they're going to be out within the next 10 minutes. And then what I'd like to do is have them eat lunch while they deliberate. So that way, just hold off on giving it to them until ready to deliberate after closing. Hey.
Is that enough, folks?
Yeah.
Mr. Takano, Your Honor, Abdul.
What's the last name? Is Abdul?
ANK
10.
and
Okay.
then ANO.
10. Cool. I see it. Okay.
So like $1,000 in EPSC, he paid 600. He's trying to pay the last 400. The state has made a PCI offer. The case is old, Mr. Honor. It's from January 1st.
Where is he here now?
He is here. I think he's waiting in the hall, but I went around the back to go talk.
Okay. Do you mind bringing him up?
I absolutely, I'll let him grab him right there.
Thanks. Hey, talk to me. Shoot.
On the docket, we're doing jail reentry. I just filed the release
Yeah,
instructions.
I'll sign it for you.
Okay, thank you.
Yeah.
Are you doing the business?
Yeah. We're doing jail reentry.
Around.
Oh.
Your case is 190 days old, sir. We set cases for trial at 180 days. You have another $400 to raise, but understand it always takes DPS at least 2 weeks from the day that you make a final payment for anything to reflect in the system, at least. We cannot hold this case open forever. I will give you one final reset, but at that last setting, that's it. If it's not all done, then another resolution we'll have to find. You understand? At the next setting, it's your plea bargain deadline. You must either have everything done or you must accept the plea bargain agreement or we'll set your case for trial. Our dockets are ballooning out of control just because over. But that's what I'm saying. I'm going to give you one final setting, 30 days, but this is the last reset. Do you understand? So don't wait till 2 days before the next setting to pay everything because that's just not going to work. Do you understand? All right, so 30 days and then he must appear and then that next setting is clear trial.
Yes, sir.
All right. All right, sir, we'll have you take a seat and then we'll have you sign a reset momentarily. Do not leave.
Thank you. Your Honor, regarding Mr. Bradford, Mr. Johnson, your docket matter, did you want him to come back in 2 weeks? The gentleman who been
I remember, what, you have an agreement worked out? Mr. Johnson, do you have an offer on the case?
He's already taken, he's supposed to provide proof that he had enrolled in bid. That was what happened. And he admits to, but then he came, well, he went on vacation, he came to court, the MAC paid for him to come to court to prove that he was coming in. And then a warrant was issued for his arrest because he didn't come back. But he has been going continuously since then.
Show me proof that he's been going. I want to see it. I want to see how many classes that he's absolutely done. The case is 9 months old, man. I can't just keep resetting it, and especially if he takes off and for 2 months.
So. You should work on it?
Yeah.
Well, I'll email you the more formal one, but that's from the coordinator. Yeah. He's been going. He had 2 absences in the beginning. His car broke down. He's been going.
When did you offer the BIP and dismiss?
We offered it on April 22nd, 2026.
The date of enrollment is May 1st, 2026.
Okay. If he misses any more classes, he will be set for trial, and I'm not doing any more resets after that. If he ever misses another day, if he ever misses another class, we will set it in 3-week increments to provide proof that he's done at least 3 classes every 3 weeks. We'll have to micromanage it, but if he misses another class, Alan, he gets immediately set for trial. Okay, all right. So go ahead, set it 3 weeks. No more waived appearances either, because it's just that 9 months is too old.
Yes, sir.
Okay, thanks. If you provide proof prior to the court setting that he's got the 3 classes done, I'll waive it.
Thank you.
Okay,
Yes, sir.
okay,
Regarding Mr. Bradford, Your Honor, we're just waiting for, I think, Chief.
Sure. Yeah.
Thank you.
Yeah.
May I approach you?
please.
Sorry.
Alan.
Oh, thank you. That's very important.
I had a coach last week on a Carlton Jackson motion to restore property. He would want proof of, I guess that he purchased it. He did go back to the store that he bought it from. They weren't able to print the actual receipt, but they wrote the minimum stating the date they wrote the receipt, the serial number, that he was the one who purchased it on the date that he purchased it.
Is it on their, it's not like on a bar napkin, right? It's on their actual, yeah, of course.
And I've attached it to the motion to restore property that the clerk said she would put in your queue.
Have you seen this?
I have not had a chance to look at the.
Okay, if you want to send them a copy too, so that they can have it for their records. And then if you don't have any objection to it,
It's a PC, it's a rifle.
I don't know if you want to.
Could you just send that to us so we have it in our files?
Absolutely.
What's the call number for your case, please?
It is 262
Okay,
0056.
did you guys?
Yes.
Man, you guys are good. Good job, really. Okay. Hey, you guys ready? I'll grant your motion, subject to their objection, of course.
Thank you.
Are you guys ready?
Yes, sir.
Okay, we're getting the charge ready.
I'm working on a draft right now.
We are too,
Oh,
so that way you don't have to.
And you have this last one. The problem, I mean, I can tell you formally.
I know, we'll do it both. Just tell me what your request is and then we'll get on the record.
Requesting that the point language of how to convict be removed since there was no evidence.
Okay.
presented.
Yeah. I'll grant it for you.
Yes, we had no objection.
Okay, got it.
Thank
Just
you.
let them know to put it in the queue. Okay, anything else?
Judge, you want to sign real quick so she can get a copy?
No.
Okay.
Oh.
Ramona, did you hear that?
Judge, he just wants the .08 removed from.
Not yet, not yet. Let me, did they just get here?
They got here while we were trying.
Oh, yeah.
Just give us 30 days.
I've been here since 8:30, you know.
Like you have to.
Oh, I guess if I could just give you a call.
Marcus.
Good, bro. You don't. Sir.
Michelle, come up, please. Guys, can you come up real quick? Ms. Brasky? Kylan, give me a second. Perfect. Hold on. Sorry. I'll send, just tell them to put in kills. Hey, look, I've got the jury charge. Take a look at it because once we bring them back, I'd like to get everything done. That way we can send them back to eat lunch and they can just deliberate, you know? Take a look, see, do you have an objection? No objection. We'll get it on the record. And then after that, we'll close. You close. Rest, they'll rest. We'll do the charge and then closing tonight.
Thank you.
Wasn't fun.
Hey,
Friedman's been fun to do this work.
really? What? What?
Is on MARDIS.
Great, so you're signing on? Okay.
I want to reset to get out around everything. I have the notes in Plato. I'm going through it. There's an operation issue.
So you're what?
Bar walk.
Okay, yeah, we'll give you a setting. Okay, he's got to be here at the next one. If you guys want to do PTI, if he wants to do PTI, please be ready.
I know.
Yeah.
I know what to expect.
Got it.
Thanks.
Have fun. Mr. Washington.
Good. Carousel here, I'm returning. Not on the board, I have two other names.
Okay, talk to me.
So the first case is into Pennington.
No, you can just.
Okay, I mean, it's 96, I don't care.
Okay, and then the second property, Haggard, HAGG.
I don't care until it gets old. Like, I don't care until it gets old, unless you're missing evidence, then let me know.
Yes.
But otherwise, I don't care. You're
Yes.
good.
Thank you.
Have fun.
Yes.
Oh. Ooh. Yeah, yeah, of course. Is it a jail plea? Oh, I see, yeah. Around.
I'm gonna get the right person on the Thank you. Judge, can I question?
Yes, I'm ready. Are we doing time, sir? All right,
No, just say Judge.
great. Is there restitution that's owed in this, on Ryder? Do you mind looking, please?
Okay, yes, sir. What was the name?
Ryder, REI.
They verified restitution was paid. They verified.
Looks like there was $1,000 that's subject to the state.
And it was,
And there was a victim service receipt that was updated.
yes, got it. Okay. Ms. Ryder, you're charged with failure to stop and give information. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 3 days in jail with credit for the 1 day that you've done. You need to understand that this charge will go on your record. It will be there for the rest of your life. From now on, you will be facing a minimum of 30 days in jail for any new cases that you pick up here. Do you understand? You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You gave up the right to appeal. If you are on probation or parole, pleading guilty to this case may result in further confinement. Do you understand this? Is this what you want to do? How do you plead to the offense of failure to stop and give information? I will find you guilty, follow the agreement, send it to it. Good luck to you, man. Please see the clerk. Thank you.
Ask one question, just on the record. Ms. Ryder, I'm not your actual attorney. Your attorney is involved when you agree.
Oh, that's right.
Sit in for you.
So hold on, I will make a docket notation for you so that he's not here and that you guys, she approves of it. Okay, great. Thank you so much. And thank you for reminding me. Totally forgot.
Can you please repeat the notification from the election to the first floor?
Okay, hey, guys, do you have any objection to the,
None from the defense.
okay, so guys, we're going on the record now. Please do not talk. If you need to talk, go outside. All right, we are back on the record in cause number 256-5785. State has rested. We have not done this in front of the jury. We will do it momentarily here, but out and in an effort to be efficient, we have given a copy of the jury charge to state and defense. State,
Sir, for the record, you have to be quiet.
sit down. State, do you have any objection to the charge?
No objections, Your Honor.
Defense, do you have any objection to the charge?
No objection.
Okay, that being said, do you mind bringing the jury in? So the roadmap is you rest. I'll ask you if you have any witnesses, you rest at that point, do the charge and then closings. 10 minutes, 15 minutes for closing. Okay?
All right, for the jury.
All right, everybody, please be seated. Members of, or, I'm sorry. State, do you have any more witnesses? Okay. State, having rested, defense, do you have any witnesses?
Defense rests.
Okay. Defense having rested now. Members of the jury, the defendant, Jaime Cruz Jr., stands charged by information with the offense of driving while intoxicated in Harris County, Texas, on or about May 24th, 2025. To this charge, the defendant has pleaded not guilty. Both sides will soon present final arguments. Before they do, I now give you the instructions you must follow in deciding whether the defendant has been proven guilty or not. You will first receive a written copy of these instructions to take and use during your deliberations. First, I will give you some general principles of law that you must follow when deciding this case. Then I will instruct you on the rules that control your deliberations. Finally, I will tell you about the specific law that applies to this case. The information. The information is not evidence of guilt. It is the name of the document required to bring the case before you. The information cannot be considered in any way by the jury. Do not consider the fact that defendant has been arrested, confined, or otherwise charged. You may not draw any inference of guilt from any of these circumstances. Presumption of innocence. The defendant is presumed innocent of the charge. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proven beyond a reasonable doubt. The law does not require a defendant to prove his or her innocence or to produce any evidence at all, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt. After careful and impartial consideration of all the evidence in the case, the presumption of innocence alone is sufficient to acquit the defendant. The burden of proof throughout the trial is always on the state. The defendant does not have the burden to prove anything. The state must prove every element of the offense beyond a reasonable doubt to establish guilt for the offense. If the state proves every element of the offense beyond a reasonable doubt, then you must find the defendant guilty. It is not required that the state proves the defendant's guilt beyond all possible doubt. It is required that the state's proof excludes any and all reasonable doubt concerning the defendant's guilt. If the state does not prove every element of the offense beyond a reasonable doubt, then you must find the defendant not guilty. If after you have considered all the evidence and these instructions, you have a reasonable doubt about whether the defendant is guilty, you must find the defendant not guilty. As jurors, you review the evidence and determine the facts and what they prove. You judge the believability of the witnesses and what weight to give their testimony. In judging the facts and believability of the witnesses, you must apply the law provided in these instructions. The evidence consists of testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, mention anything that is not in evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not in evidence in the trial. Statements made by the lawyers are not evidence. Questions asked by the attorneys are not evidence. Evidence consists of testimony of the witnesses and materials admitted into evidence. Nothing I have said or done in this case should be considered by you as an opinion about the facts of this case or influence you to vote one way or the other. You should give terms their common meanings unless you have been told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meaning provided in these instructions. While you should consider only evidence, you are permitted to draw reasonable inferences from the testimony and exhibits that are justified in light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the facts that has been established by the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice. You may, if you wish, examine exhibits. If you wish to examine an exhibit, the foreperson will inform the court and specifically identify the exhibit you wish to examine. Only exhibits admitted into evidence will be given to you for examination. Certain testimony will be read back to you by the court reporter if you request. You must follow these rules to request that testimony be read back to you. The court will allow testimony to be read back to the jury only in a writing signed by the foreperson, and 1, states that it is requesting testimony be read back. 2, states that it has a disagreement about a specific statement of a witness or a particular point in dispute. And 3, identifies the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that is in disagreement. The law requires that you render a verdict of either guilty or not guilty. A verdict of not guilty simply means that the state's evidence does not prove the defendant's guilt beyond a reasonable doubt. You may return a verdict only if all 6 of you agree on the verdict. When you reach a verdict, the foreperson should notify the court. The defendant has a constitutional right to remain silent. The defendant may testify on his own behalf. The defendant may also choose not to testify. The defendant's decision not to testify cannot be held against him and is not evidence of guilt. You must not speculate, guess, or even talk about what the defendant might have said if he testified or why he did not. The foreperson of the jury must immediately stop any juror from mentioning the defendant's decision not to testify. You must follow these rules while you're deliberating and until you reach a verdict. After closing arguments by the attorneys, you will go into the jury room. Your first task is to pick a foreperson. The foreperson will preside over your deliberations and conduct them in an orderly way. Each juror has 1 vote, including the foreperson. The foreperson must supervise the voting, vote with other members on the verdict, and sign the verdict sheet. While deliberating and until excused by the trial court, all jurors must follow these rules. 1, you must not discuss this case with any court officer or the attorneys or anyone not on the jury. You must not discuss this case unless all of you are present in the jury room. If anyone leaves the room, you must all stop your discussions about the case until all of you are present again. You must communicate with me only in writing, signed by the foreperson and given to the judge through the officer that is assigned to you. You must not conduct any independent investigations, research, or experiments. You must tell me if anyone attempts to contact you about the case before you reach a verdict. Your sole duty at this point is to determine whether the defendant has been proven guilty. You must restrict your deliberations to this matter. After you have arrived at your verdict, you are to use one of the forms attached to these instructions. You should have the foreperson sign his or her name to the particular form that conforms to your verdict. You are instructed that a person commits the offense of driving while intoxicated if the person is intoxicated while operating a motor vehicle in a public place. In this regard, public place means any place to which the public or a substantial group of public has access and includes, but is not limited to, streets, highways, and the common areas of schools, hospitals, apartment houses, office buildings, transport facilities, and shops. Motor vehicle means a device in, on, or by which a person or property is or may be transported or drawn on a highway, except a device used exclusively on stationary rails or tracks. Intoxicated means not having the normal use of one's mental or physical faculties by reason of the introduction of alcohol into the body. Now, therefore, if you believe from the evidence and beyond a reasonable doubt that the defendant, Jaime Cruz Jr., on or about May 24, 2025 in Harris County, Texas, did then and there unlawfully operate a motor vehicle in a public place while intoxicated, then you will find the defendant guilty of driving while intoxicated. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant not guilty. I have signed my name to these jury instructions. We will now allow, and each side will get 10 minutes to present final arguments. After that, you guys will be excused to the jury room to start your deliberations. Okay?
I have left, offline in,
How much time do you want?
I'll use, 1 minute, or 2 minutes at the beginning
And then,
8 minutes for the.
got it. Okay. All right. You may start.
Good afternoon. I'm sorry about all the wait. I know it's frustrating, but let's get into the facts of this case. We just want to look at the big picture first, right? What happened that night? We talked about choices and consequences in opening. And the facts are that the defendant that night decided, after one night of drinking, admittedly a 6-pack of beer, get behind the
I
wheel.
don't object that statement was not presented, and evidence wasn't proved.
Sustained.
After having a 6-pack, get behind the wheel and drive on a highway, not 10 minutes, not 10 over the limit, not 15 over the limit, 20 miles per hour over the limit. He was stopped, and you saw with your own eyes, his demeanor, the way he conducted those tests. I want you to just look at it with mom eyes, dad eyes. Your child walking home. What clues are you looking for to see if they were drinking or not? Are they stumbling? Can they walk a straight line? Just think about what you saw on those videos. Could he count straight forward? Those are the facts that we ask you to take a close look at. You'll get to take the videos back with you and rewatch it again if you want to, and I would strongly encourage you to do that, because this is an important crime. This is not, it is in misdemeanor court, but it could have been easily been felony. So it could have turned out.
Your Honor, I'm gonna object. Inflammatory remarks about how it could have turned out differently or worse. I think it's inflammatory and improper.
All right, overruled.
So the consequences of somebody's action in this case, not only can come back to them, they can come back to all of us as a community who share the roads. So I want you to look closely at what happened on that video. Not get bogged down on the details that the defense is going to try to throw these darts at you. Oh, well, this was because of this was because of that. And make a decision for yourself. And after the defense gets up here and talk, I'll come back and talk to you more and we'll wrap it up.
Thank you, Michelle.
May I judge?
Please.
So, this case isn't about just using your common sense. I mean, certainly, we don't want you to leave your common sense at the door, but the state said this is a misdemeanor case. The burden of proof is not any lower. It's not any easier for them to saddle a person with a criminal conviction for the rest of their life just because it's a misdemeanor court. It's the same very high burden of proof. First of all, you're the judges of the facts and the credibility of the witnesses, and from what you heard, I have a feeling there's some questions on what kind of a grasp did these people have on their testing abilities, on their ability to make accurate decisions when there were a lot of questions about field sobriety tests, not knowing what the clues they're looking for, not knowing how to score them properly. One of them not even knowing how to do the tests at all. But I talked a little bit about, it's like this mountain that you have to get to the top for beyond a reasonable doubt, or else you can't say guilty, you can't convict somebody. And I indicated you would hear some evidence. I think you did. Remember, it is not illegal to drink alcohol and then drive. You can't drive while you're intoxicated. And just because they put those words on a piece of paper, that doesn't mean that Mr. Cruz is guilty of DWI. That's what you're judging. You're scrutinizing everything they can present or what they couldn't present. So I anticipate that some of these, may not like some of the issues. Some of you may not like the fact that the person drank and then drove. But where does that get you? You can still find that there was some evidence. But was it so compelling, so believable, so reliable that you're like, I have no reasonable doubt? You sign that verdict form, you're like, yeah, absolutely. Some cases, they've got stronger cards. Some cases you would say there's no reasonable doubt. I don't think that's this case. We weren't trying to waste your time by having a trial. There's a lot of issues we blame on technology that caused to be a little cumbersome to get through. But this is the question: how much evidence did they present, and how convincing, and did they get to the top of where they have to for a conviction? So if this, this is like what you heard. They just have to have probable cause to make an arrest. That doesn't mean a person is guilty if an officer makes an arrest. So this is kind of the way I feel this went. You start out with suspicion, and you heard evidence of 2 sobriety tests. You heard evidence that there are 3 that are standardized and validated, that you only heard evidence about the walk and turn and one leg stand.
Objection, Judge, maybe approach.
Sure.
Judge,
I know, if you're gonna open the door. I understand, but if you're gonna open the door, you're gonna open the door. But it's intend to confuse them and. Okay, don't open the door. Okay, that's it. No more warnings. All right.
Sorry, Judge, just to be clear. I think about the fact that there was a particular reason why the third one wasn't going or was there.
Say it again.
Since he's not talking about there was three. Can I talk about it?
If you're gonna get it up, it's not fair to them, right? But if you test to confuse, you know that's confusing. It adds to confusion and it's not fair because then they don't get to respond. You know what I mean? So just please, I'm gonna instruct you to disregard that. Move on. Don't mention any more, please. Which item? Okay, but they mention that though. I mean,
That's fine.
don't talk about it. So let's do this. Mention that, and that's what you're referencing now, so they know that that's what you're referencing. All right. Okay,
May I continue?
please.
So you heard Sergeant Ryan, now Corporal back then, but you heard him talk about a scoring sheet for the field sobriety test. And there were alternate tests that are available to him to use in certain situations, because certain individuals have different characteristics. And you specifically, there were 4 tests, the finger count, Romberg, alphabet test, and the nose touch test that were available to them to use and provide you more evidence. I mean, that's their job. If they're trying to convict somebody, bring you all the evidence that they possibly can. It was even, as he admitted, on that scoring sheet, and he did not even, you don't have that evidence. You don't have any of those tests to consider. So it's like you have what you heard, and then it doesn't go all the way up to beyond a reasonable doubt. It's like it comes back down. And you'll notice that, well, it's like they're asking you to then assume and fill in the gaps and do their job for them. That's not your job. They've got the job to prove this. So, everything is based on proof and evidence. Proof. Not let's assume things that weren't presented. And the judge just got finished telling you that you can only consider evidence and testimony that was presented in trial. And I'm asking you to make sure everybody adheres to that rule. And based on the officer's testimony, we don't want to assume things that we don't know. We don't want you to speculate. That's not how you come to a decision. It's based on the real facts, the proof that you heard, and you get to decide if it was enough. But speculating about things that you don't know or weren't presented is not allowed. It's not allowed. And you heard, so there was, in Bordier, I guess you heard about 3 ways that they could prove intoxication. Not having normal mental faculties, not having normal physical faculties, or a .08 or higher at the time of driving, the BAC. Well, when you go back to deliberate and you look at the part that says the law on driving while intoxicated, you'll notice that there is no language in here that talks about a BAC at all. So this is not even something that you can consider or talk about at all. There was no evidence of a BAC level produced in proof at all. And when he came out, that was the end of, when he just came out, that was time before, that was the end of the evidence that they could present. So, y'all kind of, I hope y'all get along back there in deliberations. Sometimes they can get a little heated, but you're each other's keepers and you have a duty to stop one another. If somebody says, well, we think this might have happened, or it might have, it was probably this, you've got to put your hand up and say, you know what? We're not allowed to talk about that. You heard Judge Fleischer say that. That would be true misconduct. I don't think any of y'all are going to do that, but you got to say, stop. That wasn't presented in evidence. We're not even supposed to be talking about that. You can only consider what was actually presented. And, you know, regarding these two, your opinion is the only one that matters, obviously. But I was telling you that by looking at this video, this isn't that case where you see a person on video and you can tell beyond reasonable doubt, man, that person is wasted. They're intoxicated. That's just not this video.
2 minutes.
Not this case.
2 minutes.
Thank you, Judge. But obviously that's for you to decide, and you get to take into consideration the things you heard. First of all, who's it? Ryan said that certain things you look for, like when a person gets out of a vehicle, if they have trouble getting out, that can be a sign of intoxication, or if they have to hold on to the car for balance, that could be a sign. He said he didn't have any trouble exiting the vehicle. He didn't hold on to the car, but he writes down Ignacio had bad balance and had to hold on to the car for support. And I don't know where that came from. Who's Ignacio? I think it's kind of important to get details right in an office report that they're trying to present as evidence, and throwing in somebody else's name and things that weren't observed that's not even a part of this case. I think that's concerning. Ryan said that the only reason that he pulled over Mr. Cruz was for speeding. He acknowledged freely, according to all those nets of clues about driving, speeding is not a sign of intoxication. That's what he admitted. And he didn't say that there was any other driving facts that he noticed that indicated intoxication. Perez said that the state asked 2 or 3 times. Well, it's not unusual for the primary officer to not do the test, but do the offense report. And they asked him a couple different times. And he said, yes, that would be like not normal. And he said, yes, that would be very unusual. And that's exactly what happened here. Ryan called out for backup, and he said the purpose of Perez coming out there was he wanted Perez to take over the whole DWI investigation, but he didn't do any of those tests. And then you heard the question, like, what did you see? He didn't know how to do them. But that's concerning because he was working this special grant-funded STEP program of visa. They have to qualify, and their job is to go out. There's different pay. They are out there making DWI arrests using grant money from taxpayers, and he has no idea what he's doing. He's just out there and did what Ryan told him, just arrest him. And he said, really? That's reasonable doubt right there. So what this comes down to, you can only consider mental and physical faculties based on those awkward balancing tests, whether you thought the officers even got it right, if they really knew what they were doing.
All right, man.
Okay, so
Final thoughts.
Be strong out there. Only consider the proof that was presented. You can't talk about the BAC. And so my last thing, I mean, there was no evidence of a BAC, but we want y'all to come to a unanimous decision. But if you feel that the case wasn't proved beyond a reasonable doubt, not proved, means the not guilty means not proved. And if you feel that way, don't let anybody change your mind. Stand your ground and be strong, no matter what time it is. It gets heated back there. If that's how you feel, that they didn't prove it beyond a reasonable doubt, stand your ground. Thank you very much.
All right, thank you. Yep.
The issues, opposing counsel after arguing about being told not to open the door, they were suppressed. I counted at least 3 or 4 times and he got in trouble and done some role. He got in there and he mentioned 3 or 4 times that there was a BAC. You guys didn't hear about the final remark actually even touching on the fact that there was a BAC. There was no evidence presented. Opposing counsel knows why that evidence wasn't presented, and he's now misleading the jury as to why it wasn't presented. I understand if your quote would say that you didn't see any of the evidence presented, but to continue to emphasize it and to use it as a argument, it leaves a misleading impression, at least the state's position, Judge, and that's why we might be approached to know, can we rebut that?
What's your position?
I'm allowed to talk about what evidence was presented and what wasn't.
So they're allowed to rebut it too, then. They're allowed to rebut it as well, man. They can rebut it as well.
Respectfully, there was evidence presented.
But you told me you weren't gonna mention it anymore.
Well, I believe you know, I said it wasn't. She had not comment on what evidence they had. It's important to bring that out of your place, and they said they can.
What do you want to say?
But they did talk about it. Yes. Yes, and that he was given breath, so they heard that.
So what do you want to say? What did you have in mind?
Thank you for the fact that it was practice presentation when well, that's the reason. I think it was correct. I would just say that we're asking to anyway touch on Fifth Amendment. I would say that he said that there was no evidence presented over at Tesla. I think we should be allowed to comment on the fact that, ladies and gentlemen, there are many reasons why Brett Tesla would not be presented to a jury. And that's not something they can say. There are many reasons why it's not. They could not. And that's it. I don't want to go into politics. Obviously, we're not asking to reopen the state's case or anything.
Sure.
No.
But I mean, you.
There's an acceptable comment on the fact that since you're in. That's what.
But you got into it. How's that fair?
Didn't you hear evidence of it and why you
But like I've repeatedly asked you throughout the entire trial, not to get into the stuff that's been suppressed, and you've repeatedly pushed the boundaries of it. Like repeatedly, even at I asked you repeatedly time to time.
I didn't say it was suppressed. I said.
You're getting into that there's a breath test.
I'm sorry, Judge. But evidence was not presented, and it's the judge referencing the charge as well. I don't think I did anything. Certain things not. Didn't tell the jury. It's something that's surprising.
I mean,
it's not. How can I not comment on evidence that wasn't presented? Judge, if I may, there's well established in case law that not that it's more of an analogy about the draw judge that I can't take a swing at the opposing counsel with the shoulder of his client. If I were to go to stand directly behind him and then look at the jury and continually go, and y'all didn't see a breath test, and then look at him and they go, and y'all didn't see a breath test, and then look at him again. That would be extremely improper. Now, if I commented outside of what was presented, no, but we all agree that that would be an improper argument to make in the same way of positioning consistently that you didn't see the evidence of breath test and then trying to hide. Motion suppresses a shield, Judge. It's not a sword. Judge, I don't know what I was doing. I was careful with confidence.
The exact comment you said, you were talking about the breath test and that they didn't have a breath test.
There's no evidence, there's no proof. You can't consider that, you can't talk about it.
But now that confuses them.
I'm sorry, that's what happens when there's issues that are suppressed.
They get the opportunity to clear up any kind of confusion though.
They can't explain why it's The most we would say that there are many reasons why a breath test may not be brought forward, and that's it. It's the same ability. We're leaving them in the same boat on most stuff. He's presented one side, it wasn't presented. We just like to present. There are many reasons why, and we're not going to get into why they wasn't presented. I'm not going to ask to reopen the case. I'm just asking that we say, at least report to them that there are many reasons why. And if opposing counsel, that's
You alluded to it as well. You know, you alluded to it, and you alluded to it many times.
My comments, what evidence was present in the trial to allow them to make certain decision.
You even asked for the breath test to be pulled out of the.
Right.
And I agreed, we pulled it out, right? And but you're still mentioning it on top of that.
That it's not, they didn't hear the evidence that the state talked about in the court order. We heard it said, they mentioned it. Everyone would say that, now, if they would say that they're going to say with us, you have to talk about misleading the jury. They're going to think it was a word test. He would not be arrested if he was away. That's a problem.
Okay. So for purposes of the record, I'm gonna find that you can get into just that and that question or that statement alone. Do not get into anything else. Don't get overzealous. Nothing else. Just explain in respect to with what he's saying multiple edged. Beat it to death. Don't over and over. No, one time. And that's it. All right. Okay.
Yes, come back. 3 times.
Say it again.
I think I've tried to get my case over on the BAC didn't come out. Language was removed. I commented that there's language no.
You clearly multiple times alluded to the breath test. Clearly, several times. And I asked you not to do it. And then
Nobody said that. He said, nobody requested it.
we're not talking about the issue. You're about the breath test. All right, let's go back. Let's finish.
So I'm just about to say many reasons. Yeah,
She's just gonna say that.
Jury's coming, he said, technically, or something like that. They don't. Doesn't sit well. I don't want them to be somebody.
I asked you not to bring it up. And I've asked you multiple times for the trial when something is do not bring it up.
Respectfully, that was never discussed. You mentioned the lack of.
When I've suppressed something for you in this trial, I have multiple times asked you not to bring it up. And you have brought it up multiple times after that. And it happened with the breath test just now, multiple times again. Great. I'm gonna let them get into it as well, just for that period.
You have to excuse all the other notes I have here, but it is that statement I've read, and you have to excuse my handwriting. And my opposing counsels. But I'd like, I was attempting to keep it from even mentioning Vivian. I just say there are many reasons. I mean, something is one reason. There's consequences. You don't have that. It's okay for me. They didn't hear any of that. Because they didn't.
Did you show him? Show him real quick.
I'm okay with that.
Okay. All right, let's go. Hey, make it quick.
Just
don't be, let's, all right. You have 8 minutes, please, Ms. Shaw.
So, I'm gonna go over intoxication. We talked about the ways of us proving to you, intoxication, and that was loss of mental faculties, or, and let's remember, it's an or. 3 of you could believe, I can see loss of mental faculties. The other 3 can believe, I didn't see that, but I could see loss of physical faculties, normal physical faculties. You're still unanimous. You don't have to all agree on one or the other. It can be either or. Either one is fine. So let's talk about loss of normal mental faculties. We talked about it during jury selection, and then somebody asked the question, what's normal? And I would want to submit to you. We watched the footage of the camera. He could not count the steps. The officer told him multiple times, 9 steps forward, 9 steps back. How many did he count? 10 and 10. That has nothing to do with somebody's weight. That has to do with your loss of mental faculties. It's not normal for you to hear 9 3 times and still do 10. Counting again with the 1 leg stand when he was counting. Please pay attention to that when you get the videos back. You get to watch them again. I ask you to do that. Split hair over it, look at it. He's counting, towards the end, he's not even counting the 1000s anymore. He's counting the 1015 twice, 13 twice. Those are loss of normal use of your mental faculties. That's it. That has nothing to do with your weight. Now, about loss of physical faculties, stability that we talked about. Yes, maybe if somebody's overweight, it would be harder for them to balance. But it wouldn't be harder for them to put their heel to toe together. It would not, heel to toe. It would not be harder for them to take the turning steps. That has nothing to do with your weight. That's it. He missed all of that. He didn't do any of that. The clues that we were talking about. He missed, he had 5 out of 8. The clues on the 1 leg stand, he had 2 out of 4. Counsel was talking about Officer Perez and not knowing how to do the field sobriety test. Well, that's why he didn't do them. That's why he told the other officer, he told Officer Ryan, I'm not gonna do the field sobriety test. That's why he was observing. The only thing he did was take custody of the defendant and turn him in. He was giving you all his opinion as of today, watching the video, but he did not perform the test. Why? For the same reason counsel is pointing out, because he didn't want to do it wrong. They want to make a big deal about that, really? That he made, that's not, oh, really? They want to make you think like, oh, really, you're gonna get him? Oh, he doesn't seem drunk. He never said that. It's like, oh, really? Okay. He's just there learning at the same time. That's why there are multiple officers on that scene. It's not uncommon for officers that are in training to be on the field still working. The fact of the matter is, he admitted to drinking a 6-pack. A 6-pack is a 6-pack. The defense wants you to believe that, oh, he didn't say alcohol. What is this, a 6-pack of Coke, 6-pack of water? Oh, what were you doing at your friend's house? We were drinking water. Who refers to drinking anything else other than alcohol as drinking? We were drinking. Those are all evidence. I want to submit to you this, again, the jury charge. It says, while you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits that are justified in the light of common experience. What does that mean? To take your own common experience, or your own common sense, what Judge was saying during jury selection. You take a look at it. If it walks like a duck, if it talks like a duck, it's a duck. It's not about, what is one thing here, that it's a whole picture. Somebody drinks a six-pack, drives 20 miles over the limit at 4 o'clock in the morning. Gets out of the car, can't even walk a straight line, can't even count correctly, can't make a turn, falling over. If you can't walk a straight line, should you be behind a wheel going 20 miles per hour over? That's a question I want you to ask yourself. Make sure that I covered everything that I had here. Just, I would again want to ask you, look at the things that he says, look at the way he's talking, his mumbling. All of these are signs, all of these are, you can infer again from your own experiences. Does this person look well enough to be getting behind a wheel? Or to me, do they look intoxicated? Do they have their normal use of mental faculties with them? Do they have their use of normal physical faculties with them? The physical one was again, like I said, 3 of you can say, I think I see physical, 3 of you can say I see mental. Again, let's remember counting, a 2-year-old can do it. But can't do it when there's alcohol in your system because you can't focus. So I really appreciate you being here. I really appreciate your time. We're sorry about the wait, the back and forth. Again, council brought up the point that you don't see any BAC. There are many reasons why you wouldn't. So, thank you.
All right, thank you so much. All right, ladies and gentlemen of the jury, it's now your turn. We have lunch for you. We will now ask you to rise and retire to the room to begin your deliberations. You have an officer here at your disposal. Just whenever you're ready, let us know. All right. Oh, just go ahead and lean back and then I'll talk to you. Okay, please. Yeah, I know. That's what I'm looking for. There. Hey, you be seated.
No, it's not.
We're still on record.
Sure. Oh, no. Where does the Javon? Oh, I don't know. That's fun. Yeah. And then they should get lunch too. And then, hey, remind them 2 dings for verdict. Okay, all right. I'm sorry, Justin.
Are we off the record now?
We're off the record.
Judge,
Hi.
Governor Michael still in
Sure.
custody. I just want to go over to tomorrow.
I can't do that. Because the thing is that our jail docket is bigger than our normal docket. And we have so many people on the jail docket. We've now gotten to, we're putting people in 8 and they don't have space for their people. Because we have so many people that we literally roll day for day for day. So I'm happy to, if there's something meaningful that's going to
They
happen.
haven't done a writ in 6 months on that case, and that's why I'm having to approach, because the age of those cases, she didn't help, just 3 classes.
I understand, but she did recently pick up the new case, right?
That case is $200 bond on a criminal trespass, which is outside, like, the grass of a Walgreens.
I've done all this. I've done it with you over and
I'm
over,
not
right?
asking her to be released yet. I'm just, you want to
Yeah,
plan, I got communication with her dad and her brother.
So let's put it on for Monday or Tuesday. I don't want to just keep rolling it for day, just because I'm telling you, our jail dock is bigger than our bond dock.
I would lock so many people in jail in court 5, Judge. Never mind.
That, you know what? If you do that again, I'm going to hold you in contempt.
I just asked.
You are extremely passive aggressive and turn into a pouty child. You don't get what you want.
At all.
You are.
You do case in Connecticut.
It's unacceptable. Unacceptable.
You told me yesterday I could carry her day
No.
for day, and I told her.
And now I'm telling you that, I'm not going to argue with you, but I'm telling you, unless something meaningful going to happen, I'm not going to do it day for day for
I
anymore.
need to approach you, talk to you about the plan that you have. I need the state to do writ calls on these cases that are holding everything.
Do you
up.
have anything else to add to it?
We can set up for trial.
Set up a trial. Good. Set up for trial. Whatever day you
Set up
want.
for trial tomorrow.
No, I have to give them time and I have to be fair to the state, Justin. Is setting it tomorrow fair for the state?
No, I mean, can we come back tomorrow to set them for trial? Or are you saying? set them for
No,
trial?
no, because it's not fair to the state. It's because we have a mental health prosecutor that's working the cases. She's not
She
here.
says she's not. She says that these prosecutors are handling the
Okay,
case.
I don't know. I have not heard that from her. All I know is that she's been the one that's been working these cases for the last couple settings, and I don't know. Okay. Do you have anything meaningful that's going to happen tomorrow?
We can set it for trial tomorrow. Maybe not try the case tomorrow. Tomorrow we come back, bring more supers, bring whoever you need here, and we set.
Can you reach out to Ms. Stubbers, please, to see if she can come here now, please? Thanks. All right, give me a second. Let me see if we can get her here. Hey.
Judge. Okay, can you pre-trial, we got some development on the case, okay? Thank you, Councilwoman. This is the one that I approached on about the income under. It is working. And that's what my client had told me. And so she just confirmed she did get a new.
No, but she didn't let them download the information to find out things. She refused to let them download it, correct?
Yeah, so I took a look at the timeline. So on Monday, she came in and she got a new device and then it still was not working because she said that it was a charger issue. But we couldn't give her a new charger without the old one. And so then that's when she showed up yesterday. And she brought us the charger and we said, can we look at the device? Because we still don't know if it's a charger issue or device issue, and that's when she pointed us to people.
But she got a new charger and she charged it and it's on, it's working now. That's my thing.
Are there still other bond violations?
So she had a no, cell, no GPS battery from about 2 o'clock.
She needs to be here so I can admonish her. It's already one bond violation. Presumably, it might happen again, and I'm gonna admonish her that there's absolutely no tolerance going forward. So she still's got to be here.
Okay, Judge.
Sorry.
And then, sorry, I'm here on bond condition, even for the other case I talked about, the DWI with the police.
Sure.
So, two questions. One, he sent me, basically the invoice and everything, and it's an alcohol-free pass, Judge. So he's not gonna even be able to have alcohol on the.
I don't know that for sure.
Okay.
I don't know that.
Can we test him?
No, because I won't be able to see if he has it. I don't, after 24 hours, alcohol dissipates from your system. And I do not have a test that will reflect from, if he could conceivably drink on Monday, comes back next Monday, and I will never know.
And then, can we waive his signature so we can?
Yes.
The pretrial to do it?
Yes.
Agency pay?
I'm okay with
Thank you, Judge.
Yep. Hey,
Judge, Galen Valley. She appeared this morning on a VDR. I thought I saw her sitting in the box.
give me 1 second.
Yes, sir.
I'm gonna need you to go on the record with him. When Ms. Steppers comes, I'm gonna go on the record with Justin,
Oh, okay.
please. Okay,
Galen Valley, she was appearing today on a VDR. She was present in the box earlier, Judge, and she's disappeared. I think the bailiff's asked her to step outside and maybe she misunderstood. She left or
okay.
whatever.
You wanna roll it till tomorrow then, or I guess till beginning of next week?
Yeah, let's roll the beginning.
What's the bond violation?
The bond violation was that she failed to show up for a UA.
Okay.
But Judge, when we put her on, when you put those conditions on, she was homeless and didn't have a phone.
Right.
And so,
All we have to do is go take a drug test.
right.
So I'll set up for bond forfeiture. All I wanted to do is go take a drug test,
Gotcha.
you know?
I wish I would have been here earlier.
I get it,
I'll roll her in next week.
beginning of next week,
Beginning
okay?
of next week.
Yeah.
Okay.
SFPF.
Thank you.
Yes, sir. Ms. Washington, you ready?
So we're waiting on the interpreter.
Okay, all right.
Yeah, I'm just waiting.
Hey, you have an arraignment? Oh, he's here.
Oh.
Spanish, right?
Yes.
Okay. Do you need to talk? Mr. Perkins, do you want to talk?
I have a plea, but I'm missing one signature, so I've got it.
Okay.
Interpreter, a walkthrough.
I need, hey, Luis, can we borrow you for a second? Luis, can we borrow you for a second? Do you have a pause number?
I do, Jeff.
What is it?
262. 7641. Assault family.
What's the last name? Or, don't worry, I'll get it.
Yes. Also.
Did you get the cause number? 2627641.
If we have a bonds person here as well. The court agrees.
I have Mr. Metz signed on to the case.
That's correct. His office is here. I'm standing at first.
Ah, okay. All right, you are Miss Alberto Hernandez. Ma'am, you were charged with assault of a family member. You were facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On June 28th, 2026, in Harris County, Texas, officers responded to a call in reference to a family assault. Officer met with complainant who advised he was assaulted by his wife. The complainant or the defendant arrived at the location to pick up the belongings. Complainant reported while inside the residence, the defendant began arguing with him. Complainant advised he no longer wanted to be inside the residence and attempted to exit. Complainant advised the defendant placed her body in front of the door and refused to allow him to leave. complainant reported as he continued trying to leave the residence. The defendant struck him one time with an open hand across the face. Complainant was able to leave and call 911. The complainant reported feeling pain during the assault. An officer observed redness and swelling on the right side of the complainant's face.
Okay. Ms. Hernandez, I'm going to find that there is probable cause to go forward with your case. As a condition of your bond, you were ordered not to have any contact with the complaining witness in this case and not to be in possession of any weapons. I am entering now what's called a magistrate's order for emergency protection, which is a court order that identifies Mr. Sanchez Maximo as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where he lives or where he works. If you violate this court order, they may file additional cases against you. In a violation of protective order, they can file it. It's one of the worst misdemeanor cases you can pick up. I don't know what your immigration status is, ma'am.
Mr.
But if you are not in this country with proper permission and you go to jail and immigration finds you, they may place a detainer on you and you may be in custody for a very long time. You have a lawyer. It is your responsibility to stay in touch with counsel. If they tell me they cannot get a hold of you, if you do not show up to court, then likewise, a warrant for your arrest will be issued. Let's talk about a bond.
Judge,
You have a request?
much about this summary, I'm stepping in for Mr. Metz.
Sure.
But I'm told that she could make a bond of somewhere between $2,000.
We'll defer to the court, Your Honor.
I was going to grant you a PR bond if you want one. Does she have any criminal history?
I'm running for NCIC right now, Your Honor. No criminal history, Your Honor.
Okay, I will set your bond at $100, Ms. Hernandez, and I will grant you a PR bond. I want you to understand this is not a revolving door. So it's not PR bond after PR bond. If you are a danger to our community, things will not go well. Do you understand?
Yes.
Okay, we will have all the paperwork drawn up. They will have bond conditions created for you to sign. Once you sign that and then the PR bond after that, you'll be free to go.
Thank you, Judge.
Oh, good call.
Judge, the conditions are no contact allowed.
Please. Yeah, thank you so much. Yeah, let's do it. All right, Mr. Perkins, you ready?
Deja Turner.
Yes, ma'am. Yes, sir. All right, good morning, Ms. Turner.
Have one question, can we, when the court calls concurrent?
Is it a true first?
Yes.
Yeah, then yes.
And I told her you'll set the suspension and there was something else that escapes from it. Oh, the surcharge, you need that form filled out?
Correct.
Okay.
Yes, Ms. Turner, you're charged with driving while intoxicated. First offense, it's elevated to a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement. They're offering you 12 days in jail with credit for the. Is that right? So she has time to do.
Yeah, she still has, she's gotta go in and do 3 days.
Okay.
That's why I was asking, can she, her court costs ranking her with.
Is she going in now? Do you-
Yes, sir.
Okay, all right.
Excuse me, I apologize. Yes, sir.
Okay, so understand it's 12 days in jail, credit for the 1 day that you've done. You need to understand something very important, that this charge will go on your record. It will be there forever. From now on, should you pick any further ones, you'll be facing a minimum of 90 days in jail. Do you understand? Every time you get pulled over, officers will see this DWI. If they come up to you and they smell alcohol, they smell anything funky, that it just may not go well. So for the rest of your life, if you use, I'd just be very, very careful. You understand? You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this. Do you understand? If you're on probation or parole, this can be used to revoke that, resulting in further confinement. How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty. I'm going to suspend your license for the minimum, which is 90 days. Do not drive until you get a license. I will roll your court costs for you today. I'm rolling about $6,500 worth of fines and fees for you today. Ms. Turner, you don't get to redo over and over and over. If you pick up under the DWI, a second, it's a surcharge of $6,000 at a minimum. And if you don't pay it, every $100 you owe, it's 1 day in jail. You understand? Be very careful. I would, if I were you, for $30 an Uber. Good luck.
One last, there's, go ahead. Just, I've had some fun with the DVRs in court in her particular case, because she had too early on DVRs, that's why they denied her. But during the next 90 days, gave her the scram, and on the low device, she had one come up, but on the scram device, she was perfect. So I don't know if the low device was off or the scram device, but I'm giving you some information. about the
That's
scram,
why
and that's why we
tell
did
them,
both.
you know, when you blow, it could be a false positive. Wait at least 20 to 30 minutes before you do, so that there is no false positive, because who knows what it is.
In my checking those records, though, I just wanted to let you know, sometimes one or the other could be.
Okay.
Thank you, Your Honor.
Tyler left.
Yeah.
Well, you represent Stupers, STUPERS.
One of them is 2627300. Do you need it all?
Your guys ready? Come on up. Before we get into the case, I need to address something with you. We are on the record in cause number 2601312. For purposes of the record, I would like to state that I was having a discussion with the defense lawyer, Justin Harris, and Mr. Harris was rude and passive aggressive. This is not the first time that this has happened. It has repeatedly happened, in so much that in December, if I remember correctly, he called me a Grinch. I had a bunch of students out here speaking and trying to make a point in front of the students, and he tried to dress me down in front of the students, which was extremely disrespectful, so much so that the students and the professor really took note. Today, again, July 8th, 2026, passive aggressive and rude happened again the other day, where today he made the comment that why is everybody in court 5 always in jail? And I really take note to that. And I'm going to tell you that from now on, the interactions that you and I will have will be always done on the record. So from now on, when you and I discuss whatever case it may be, it must be done on the record. We will have no more discussions unless there's an actual court reporter here taking every single thing down. Okay?
May I respond to it?
Sure.
Okay, I like that because the law is actually that everything is supposed to be on the record that can happen in the courtroom unless both parties agree to waive it. So the court should be taking every single thing on the record. And I'm glad that we're gonna be doing that. I will say for the record, I did not I did not say, why is everyone in court 5 and is full over? What I did, the court indicated that yesterday on this case and my client's cases, the court indicated I could carry her day to day until I have the information that the court requested I get to consider her release. And so today I asked the court to carry the case to tomorrow, like they did yesterday to today. And the court indicated to me that the reason that could not be done was because the court's holdover was full. So I just asked, why is the court, you said that you have more people on the jail docket than you do the bond docket in your misdemeanor court. So I asked the court, why is the court 5 holdover so full? I didn't imply that there's too many people in jail. I didn't use a judgment call like the court seems to think that I did. I don't think that I was rude in any way. I don't think that was passive aggressive. I think as both a taxpayer and a practitioner in this court and someone who's being told the relief I'm seeking is denied for that specific reason, I think it's a valid question. You cited the holdovers overcrowding as the reason why my client can't be put on the docket tomorrow. And I don't necessarily even need her here if the court doesn't require her appearance, but I need to be able to address the case on the court's docket. So if it's because of the holdover is too full, I don't know why my question about why the holdover is so full. And it seemed like there was enough space for there yesterday and today. I don't know why that's an invalid question. And I don't know why the court takes offense to that. I think the court should be receptive to, accountability and answering questions of people who practice in there, and as well as the voters of Harris County and the residents of Harris County. That's all I was exercising my First Amendment right as. So I'm not sure what's offensive about that to the court. And the court recalling previous incidents, I don't know what that has to do with this case that's on the docket today. And all I'm asking is what the court told us 2 days ago and reiterated yesterday by allowing is if we just carry her case to tomorrow, we have someone who's the state feels is not mentally all there, has mental health concerns. The state's indicated they have an orange sheet with mental health history that's unspecified. I have concerns about my client's mental capacity for her developmental capacity. And she doesn't speak the primary languages that are spoken over at the jail. She speaks a dialect of Ethiopian. She's a very vulnerable person in the jail. She's being held on a $200 bond on a Class B criminal trespass, where the warning, according to the dim summary from the state, the warning for the trespass comes the same day as the arrest. And she's not in a business, she's outside in a grassy public space that I don't know if anybody could discern if this is private property and this is not private property. But again, the court is holding her at great expense to taxpayers. The court is paying me for my representation of her. And I'm just trying to get the court the information that you've asked for yesterday regarding the plan for her release. I have told the court earlier, I have plans this evening to speak with her father, who got contact information from him, and her brother, who I'm trying to get contact information for. Her sister, who I told the court about yesterday, is not in town right now. So I don't want to bring that information to the court, like let her go back to sister's house when sister's not there. I'm trying to bring relevant material information to the court that the court requested. And the court is now throwing up a hindrance to that by saying you won't do what you told us you would do 2 days ago, which is carry the case day to day.
Give a response.
As far as the allegations we discussed earlier between the court and defense, the state was not present for that. Personally, I just, fun fact, counsel, did you know that court 5 is fugitive document?
I do.
So that might, I don't know if that's the reason, but just throwing that out there. As far as the allegations, I will defer to the court's ruling yesterday that he was not going to reduce the bond. I'm opposed to a reduction of the bond in this case for reasons I stated yesterday, but
The reason I wanted to bring you in here now is because I did not want to continue rolling this case day for day. We have way too many people that are on the docket getting rolled day for day. It's not fair to the other inmates who are crowded in there. It's not fair to court 8 because we're having to put people in court 8. So I don't want to continue to do that.
Yes.
Mr. Harris's response to that, well, let's just set the case for trial. And I said,
Well,
I'm not going to stop.
that's not what I said.
Stop. I'm not asking you to respond at this point.
Okay.
I'm talking to her.
Okay.
So before we set the case for trial, to be fair to you, because you're the person that's been here in the last couple settings, I'd like to know what your response is before we set this case for trial.
Certainly. My response is that I was opposed yesterday to rolling day for day due to the fact that I don't see us moving forward until we get the results of that competency report that defense filed for. Now, I have extreme concerns about defense now wanting to set this case for trial because he previously asserted to myself and the court by filing that he believes his client is incompetent to stand trial. So it's my understanding now that you want to still set it for trial, even though you believe she's incompetent.
I have never said that I believe she's not competent to stand trial.
We got a comp evaluation
Right.
per a filing, no? Am I
Yeah, no, that's
correct on
correct.
that?
It's a psychiatric
Or you
evaluation request. The
assert
state asked us to
That she
do,
may be
One at a
incompetent.
time.
the state asked us to file that because the state indicated to me that a lot of times those evaluations will come back and indicate if there's any kind of intellectual disability that they're starting to note. So that's why the state wanted us to get that evaluation done. I don't right now have enough information to say that she doesn't understand the charges against her, that she's not able to aid in her own defense, and that she doesn't understand the role of the parties in the case. That's the legal definition of competency. So, but at this time, I don't have any of those concerns on those 3 things as of today's date that we're on the record. Additionally, the court asked me what we could do tomorrow, it would be something meaningful on the case. And I said that if we came back tomorrow, and now Ms. Stubers is here, but if I'm able to get the information that I have, I can present that to the court about her release, the court makes a decision on that, then we may set the case for trial. There was some confusion at the time. I'm not asking to set the case for trial. I'm just trying to relay what we talked about earlier. You weren't here at that time. And so, but the state who was at the bench with us at the time indicated that, well, the court was under the impression that the trial prosecutors in this courtroom are not handling the case. And I relate to you that Ms. Stubers told me that she's not handling the case. She just oversees the mental health pretrial intervention if it ends up in that way. And it's not being offered at this time and it's not at that point. So, and then also Ms. Shaw, Shantia Shaw, who's the prosecutor who's handling the case for the state, indicated to me in the hallway before we came back in here that she has no problem setting this case for trial. And so the reason why I was saying we come back tomorrow, and the court asked what we could do tomorrow. And I told you I would have the information the court requested yesterday about her release plan. I think that's meaningful that we could do tomorrow. I also think that if that doesn't work, if we have that information and the court's not satisfied with that, then at that point, I'll probably need to set the case for trial. So that's what I was responding to the court for, is tomorrow what we could do is we could set the cases for trial, as well as present you the information I'm trying to get this evening.
I will note that counsel did send me an email yesterday evening saying that he would set it for a trial and request a speedy trial. Also, I would like to note for the record that I do not subscribe to any of the statements that he claims that I have made. I know for a fact that they were not said in the way that counsel maybe understands them to have been. Because it is not true that anybody from the Harris Center during a competency to stand trial evaluation evaluates a client, a defendant, or anybody for intellectual disabilities. What I told counsel, I remember specifically, is that sometimes they will indicate that that might be present. However, they cannot make that diagnosis in the exam that we undergo. Per the filing by counsel that states he filed this motion. I don't request counsel file these motions. I am able to file them myself, Your Honor. If I wanted to, I would. But counsel did file this one himself on May 8th, and he says, quote, defendant has a history of mental illness. Defendant does not have sufficient present ability to consult with the person's lawyer with a reasonable degree of rational understanding, and or defendant does not have a rational as well as factual understanding of the proceedings against the person.
Are you telling me that he emailed that to you?
No, he filed that. This is the filing that counsel made to get the competency exam done at all, which we did then expedite personally, and it came back in a week versus the usual month long that it takes.
So
to get
it's
someone
back
examined.
though.
They did the evaluation.
It's not
the other
back yet.
day, And it's not back yet.
Okay.
And that is exactly what I've
Okay,
been
I'm
trying
not gonna
tell
set this case for
counsel.
trial if you're alleging that she's not competent.
Judge, that's like I told you a second ago, it's on the
So you've
record.
withdrawn your allegation that you believe that
Hold on a
she's
sec-
incompetent.
Hold on a second, like I said a second ago, as of July 8th, today is today's July 8th, I don't have the concerns that she is not able to aid in her own defense, that she doesn't understand the nature of the charges against her, and she doesn't understand the role of parties in the case. At the time of the filing, I didn't have the information that I have now. So no.
What has changed between, when was that filed?
That was filed on May 8th, Your Honor, and then we were discussing more about getting the comp report done per my case notes on, I believe, June 30th. If I'm not mistaken. That might be in my emails.
So you're saying you have no concerns about any competency whatsoever at this
time, I don't
point?
have anything that I could say, this makes me concerned about this issue, or this makes me concerned about this issue, or this.
So you're saying she's competent at this point?
I don't have a way to say that she is or she isn't something. I'm just saying I don't have the things that are required for me to go, I have concerns about competency at this time. But I'm telling the court on the record with my bar card on the line, that the reason why the state indicated we should speed this along was because, like she said, that might indicate IDD, if IDD is going on. And I don't know what the record says, but my recollection is I'm not saying that the state said that 100% they're going to
Okay, I
diagnose her
don't,
with
I'm not
IDD.
trying to get into,
But
I
what they
just,
said,
how do
they
we go
told us,
forward?
I'm just telling you what the conversations I was part of and what made me motivated to agree to the things that we agreed to was the state indicated that, as they said today, now, that sometimes in these mental health evaluations, the evaluator will note if there's intellectual disabilities. In fact, I feel like we even emailed Helena White earlier this week and we asked her
Yeah,
to
you
look
said
for
to
that.
do that,
So-
however, she never responded because they can't do that.
But just try not to be interrupted, Judge. But the state was party to all that. The state indicated to us that the IDD, that's what we're looking for. Because
What do you want?
I want to carry her to tomorrow so I can bring the information to the court about what she's got going on and what her release plan will be.
But you say there's still someone else that you may need to talk to because you may not have everything tomorrow.
I have her dad's contact information. I'm going to get her, he and her sister has her brothers. And when I get out of here and I can make phone calls, then I can call and get her brother's information. Between her brother and her dad, I think we can get together, we can put together the plan that the court needs to consider her release.
By tomorrow?
Yes, sir. It's just going to be a matter of conversation. They telling me who her providers are.
I asked you for proof other than word though.
I know. Let me see what I can get to you. But that's the thing is if I'm able to get it and we have somebody that's got these kind of capacity issues in the jail who doesn't, English is not her primary language. She's vulnerable in the jail, Judge. And if we have that tomorrow, I'm just asking to carry.
And what if we don't have it tomorrow? You're going to want to carry it the next day too?
I thought that's what you told me 2 days
Okay,
ago. We could.
yes, I'm now changing my mind.
Okay.
Because we have way too many people in the holdover now. That's why.
You just told me today that you're changing, just now
Yes.
you're changing your mind.
Sure.
So, and I've just been asking for what the court previously told us, before you told us.
I
you
will
changed
give
your
you
mind.
tomorrow, but if tomorrow there is nothing that is changed or a different plan, I'm not going to continue to roll it day for day for day for day.
Okay.
Okay, but I will
understand
give you to tomorrow, but after that, if nothing has, I'm not going to continue to do this day for day.
Understood, because I get that, because I'm sensitive to the fact that Fridays, especially after a holiday weekend, are going to be slammed crazy for
Right.
probably in your holdover. So we carry to Thursday, and if we don't have a resolution, instead of Friday, we do like Monday or Tuesday.
I'm not going to commit to anything at this point,
Okay.
but I'm telling you that I'm not going to do day for day anymore.
Okay.
I will do today to tomorrow, but after that, it's just if.
That works.
Just for everyone to have full information, I am out of town on Friday and Monday.
Okay, great. So we will wait, obviously, for you, but let's see what happens tomorrow.
Okay.
Okay.
Just for the record, since my name was brought up, Shantia Shaw for the state, I did not outside tell counsel that I am ready to set this case for trial. Counsel was threatening that what if I set this case for trial? If you don't do the RIP, I said, you have every authority and every right to do as you wish with your case. And I told counsel that my understanding is that the writ has nothing to do with holding this case as of right now or for his client to be still in custody right now. And that was the conversation. So I just wanted to clarify that I did not say we're ready to proceed with the trial.
All right.
I'm not saying that she said that she was ready to proceed. She did say that she was fine.
It is what it is.
Okay.
Just, all right.
You charge it tomorrow?
Yes,
Thank you. Off the record.
off the record.
Thank you.
Do you have a question? Hold on. Let me.
Yes, sir.
Hello.
Hey, are you here?
Yes.
Can you come back up real quick?
Yes.
Thanks. There's a question.
Okay.
Bye. All right, he'll be right up.
Yes.
As soon as we, ready?
Judge, did you, email Ulysses for the laptop?
Oh, no,
That's what they're asking for, right?
right. Thank you for reminding me.
Only we get followed, but if you wanted us to notarize and you people, you can't do, you want to only put it in. If it's your classified, it's all with the way.
Oh, we need a laptop so that jurors can view a video, please. Thank you so much.
Put it on your, just.
Tyler. They just want to look at the body cams for both officers, so I just wanted you to see it. They want to see both body cams, Reyes and the only thing is do we have the right ones there so we know which ones they're getting? I guess you want to make sure.
We gave it yesterday, we edited them all, the way they were supposed to be and submitted them to them.
Like the HGM, the video part with the executive.
Yes.
You want to take a look real quick?
Yeah, just in
I
that.
mean, we're waiting for a computer for them anyway, so do you mind just looking real quick just to make sure, please? Okay.
Wait, let me see something.
Talk to me.
Wait until they.
It's okay. They're gonna look at video.
Case on docket today, Judge, 2628004, last name Garcia.
Garcia. Okay.
So he got booked out on 7/1. It's a refusal, but he's been rolled day to day because he's being combative with the jail, so he's not being brought up because he's being so combative. I don't know if it's physical or verbal, but it does prove to show that he's also charged with harassment of public servant and retaliation, so he threatened to.
Yeah, you see the spit guard?
I'm sorry?
See the spit guard?
So
Yeah.
part of it is because the next setting for the felonies in the 42nd is the 29th, I didn't know if you wanted to appoint somebody to go to the jail or if you wanted to just keep rolling until.
No, he needs a lawyer. We can't just continue to. Victoria? Let's appoint a lawyer. We'll see if they can get out there. If not, then we'll do maybe a Zoom from the jail.
After
but-
the third one, I usually ask if checks in, make sure it's not medical or something else. So he's just extremely combative.
You ready?
I'm ready. I'm ready.
Okay. On Garcia jail case, Victoria, he's been rolled day for day. He's not made it up because he's been combative. Do you mind just appointing him? Then we'll see if they'll go to the jail to talk to him. And if he refuses at that point, I'll reach out to admin, see how we can facilitate. Has he waived or do you refuse?
Which is part
Well,
of it. Because-
it's,
Well, I mean, but the problem is with the refusal, part of it is if it gets to the hearing, he is afforded an opportunity for an attorney. So ironically, by making it.
So then let me clarify.
Oh,
So
sorry.
he technically didn't refuse. PC court could not get him to come because he was spitting at the detention officer. So Judge Chu just did the refusal. Because if that's the case, they were gonna keep rolling him on probable cause
The problem is unless they affirmatively waive away their rights by legal default to refusal.
Okay.
So
Regardless, we'll get him a lawyer, have the lawyer go reach out to him. If it's, at that point, they're still refusing, then I'll reach out admin and then we'll get Sylvia involved.
Okay.
Yeah, okay.
I'll check in tomorrow and then.
Yeah,
figure it out.
okay.
Thank you.
Thank you.
Thank you, Judge.
Are you ready, Alan? All right.
That's a help.
All right.
It's not this one, right?
No.
All right. Good morning, Mr. Godfrey. So,
I didn't know they had children.
he's only planning on one.
Yes.
The rest are being dismissed?
Yes, Your Honor.
Okay.
Your Honor, if I may, I had asked if we could get this signed under the seal of the court. This is just a statement that I had Mr. Godfrey sign acknowledging that he understands that there was a global offer that is being made that, against the advice of counsel, he's pleading guilty right now. Understanding that if there's a PSI would be upstairs, that they could take into consideration the convictions associated with this court. I have advised him of all of these things, and he still decided he's running to guilty. So I did just want to have that on my record. Again, I don't know if I can get the statement signed by the clerk, I mean, stamped by the clerk of the court, I just want to do so.
Did you hear what he said? So it looks like it's a kind of a COIA type thing where he files it under seal. What do you think?
We something we can follow, but if we follow his procedure, we granted, we just need a prescription saying that you grant to follow it under seal, because he wanted us to just kind of notify him. And I guess he keep it, we can't do that, it's not a district court document, but if he wants to follow it in his case, we can't do that.
Yeah. When it's under seal, will he get access to it?
No.
You hear that, right? So when it's under seal, they're not gonna get access to it. I don't think that you get access to it either, though.
In that case, Your Honor, I would have preferred if I could not have it stamped, at least.
I can make a docket notation. If you want, we can put it on the record because I've got Ramona here as well, already ready to go.
Yes, that's the next question.
You want to do that?
Please.
Ramona, I'm so sorry.
Wait a minute. Your Honor, Mr. Godfrey.
She's earning it today.
This is Mr. Godfrey's last time being in trouble, but he is the case that keeps on getting.
You know, I hope no one wants to see you just become another statistic, but you know, a lot of this life is who you're with. Are you with the wrong crowd? Are you the wrong crowd? But Mr. Godfrey, here you are with 1, 2, 3, 4, 5, 6. And a lot of them are dangerous cases. So, you know, at some point, your decisions become your own. At some point, all you're doing is running to prison, and life as a young Black man in today's society, it can't be more difficult for anyone than you, my friend. And by picking up all these cases, instead of getting your butt into school and trying to learn something, so you're charged with, oh, I'm sorry. Are you ready?
Yes.
All right, we're on the record and cause number 254-6510, 254-6509, 258-6956, 258-6955, and finally 261-3612. 1, 2, 3, 4, 5. The agreement that you have worked out is 180 days in jail, 6 months in jail for credit for the 96 days that you have done. Understand something important is that it's very possible that your lawyer may work out a global resolution with regard to the case upstairs and with this case downstairs, so that there may be a whole different resolution. Not only that, depending on what you do upstairs, by pleading guilty, they may also use that against you upstairs. I don't know what's going to happen, but when you get convictions on your record, it's very possible that they're just used against you, resulting in further confinement. Do you understand?
Yes, sir.
I'll give the floor to you so that you can
Thank you, Your Honor.
Tell me whatever you'd like, or the court, or
Yes, Your Honor. On today, July 8th, 2026, I did speak with Mr. Godfrey where he did in fact sign a statement that says in part, my name is Javion Godfrey. I acknowledge that my attorney, Alan Woodward, has advised me of my rights, which signed. I have the following misdemeanor charges pending: 254-609, 254-6510, 258-6955, 258-6956.
Hey.
Oh, sorry. I'm sorry, I forgot.
Slow.
I forgot you. When you started with the numbers? Okay. 254-6509. 254-6510. 258-6955. 258-6956. 261-3612. I also have a felony pending that could result in a sentence of more than 10 years in the Texas Department of Corrections if I am found guilty. I have been advised by Attorney Woodward that it may not be in my best interest to plead guilty to any or all of the misdemeanor charges. I have been advised that the state has considered and offered to dismiss all misdemeanor charges with a plea of guilty on the felony charge will be signed. Against the advice of counsel, I am rejecting any offer from the state to globally resolve all cases, which you signed. And I insist on pleading guilty to any and or all of the misdemeanors listed above. Signed, J. John Godfrey.
for purposes of the plea, he's pleading guilty to one
Yes, Your
and four being dismissed.
Yes, Your Honor. For the purposes of the plea, he's pleading to 261-3612. Self-condemnation.
Knowing that your counsel is advising you against this, do you still want to do this?
Yes, sir.
Okay, you're charged with assault, bodily injury, you're facing a year in jail and or a $4,000 fine. You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, this will go on your record. It will be there forever. You can never change it. You will now be facing, for any Class A misdemeanors, a possible up to 90 days in jail for any future offenses that you may pick up. If you're on probation or parole, this can also result in further confinement. Knowing all this, do you still want to go forward?
Yes, sir.
How do you plead guilty to the assault? Guilty or not guilty?
Yes.
I'm going to find you guilty. I will follow the agreement. As far as the weapon is concerned, it will be forfeited to the state. And good luck to you, sir. Okay, we are done. And as for purposes of the record, the other four will be dismissed on motion of the state.
Is your
Okay,
Thank you.
all right, off the record. Okay,
Mayor Thomas, I'm Thomas, sir. We're already on.
yes, you've satisfied. It is,
It's 96 days and it's
6 months. So it's, hold on. Let me just make sure, because I don't want to tell you wrong. Yeah, assuming they give you, the credit that, you've got sufficient credit. But you need to be careful, man. Every day, people are dying out there because they just make the wrong decision, just in a moment's notice. Do you understand, Mr. Godfrey? All right, good luck to you, man.
Thank you, Your Honor.
Yeah, let me talk to Mr. Washington, and then, hey,
I'm circling back on this, Hernandez.
okay.
Walkthrough. We just need to get you.
Oh, yeah, I'm so sorry. I'll get it done. Do you want to bring her up?
We've done everything, the bond conditions.
Okay, I'm signing it right now.
Thank you so much.
Of course.
You guys are correct.
Okay, are you ready on that arraignment?
Yes.
Let's do it. Coming up, sir.
Judge Jones, Harrison is coming up.
Harrison, what time did Mr. Harrison get here? Is that right?
I didn't have them marked off.
We don't have you marked off. If you don't come in and check in, no one knows that you're here and you end up waiting. This is what, I don't know. Mr. Harrison, you're charged with harassment. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Harrison. He has an assault that was dismissed. 1, 2, 3 that were dismissed. Not 3 months ago, man. Go ahead.
May 8th, 2026, officer was dispatched to a location in Harrison County, Texas. Complainant observed a vehicle that belonged to the defendant that she knows have been briefly trespassed in that location. Complainant allowed the vehicle on the premises because the driver was a female and she did not know he was inside. Complainant noticed the defendant walking around the property and took pictures of him to document his presence for the company records. Complainant stated the defendant saw her taking a picture and approached her aggressively, yelling at her, and put his hands inches from her face and said, quote, "Bitch, I will slap the fuck out of you," quote, "I will beat your ass," and quote, "I don't care if you're a woman, I will beat the shit out of you." Defendant threatened to wait for the complainant to get off work and stated, quote, "I'll come back and beat your ass in the parking lot." Pictures and videos confirmed the defendant to be on the premises.
What is this place, please?
It's I believe it's a company, looking it up right now, I think it's Watco Company,
What is it?
Watco, WATCO. Yeah, a company called Watco.
Mr. Harrison, I'm going to find that there's probable cause to go forward with your case. I want you to understand something. I want you to hear me loud and I want you to hear me clear. I'm going to do everything in my power to protect my community. And if I have to throw your butt in there and give you a $5 million bond, I will do it in a freaking heartbeat. Everything. You so much as any violation, it's not going to go well between us. You are ordered not to consume alcohol or illegal drugs, and you will be tested. It's not a matter of if, it's when. And I'm telling you, within 50 days, you will be tested. You test positive for anything illegal, it's not going to go well. Do you understand me? This includes marijuana. This includes unprescribed controlled medication. It includes alcohol. You are not to be in possession of any weapons, and I will give you a GPS monitor, and you're not to go within 1,000 feet of this place or the complaining witness. Do you understand? Do you mind tagging on the device on the GPS monitor so that the complaining witness knows if he goes near, please? Test in 50 days. We are going to reset your case to give you time to hire a lawyer. So I will have you sign a reset. You will get with pre-trial bond for your bond conditions. Any violations? Do you understand me? Yeah. Oh, you need me on sign?
Yes, it does, refer to the decision.
Got it. Yeah. Hey, Ramona,
Yes, Judge.
can I talk to him back for a second?
No, I knew it was gonna, read the prophetic verse, yesterday. I was like. I still look good. That's good. Yeah, I don't know. I don't know nothing. So we be using our marbles for. Put it in this water. I should have had her.
After it was, I think there's a phone number in.
Do you want me to leave it as a jury trial?
Yeah. Please. Hey, is that Morales over there?
Was worried about the length of the chair. For months. I can look at it.
Hey. Do I need to answer? I don't need to answer this, right? Can I just sign it and?
Just give it to the clerk so they can put it in the file. You don't have to answer. Just.
Yes, ma'am.
Put it in the- Thank you.
My thoughts that
That's okay. Morales' lawyer, she was here earlier, I know, but.
She said she is a right
No, but he has today court.
Only because he's on the show yesterday, but he didn't make it up, so for today, his bond paper, the attorney showed us. Because it's not. So she said she was out.
Yeah, I don't want to wait that long. It's his third case, man. You know, really, it's time to. So. Hey, can I talk to you for a second? I want to reach out to, she left, the lawyer from Morales left, but I'd like to reach out to her to get her here sooner. he's on his third case now, so I'm not gonna just sit here and wait and, because half a week, it's time to. So I just want to let you know, so that way I'm gonna see if she can come in tomorrow or maybe Friday.
I may, probably won't be here.
Yeah, okay, I guess I should have said Ms. Shaw.
I'll let him.
I'm reaching out to the lawyer for him to try to get her here. She left already, but maybe tomorrow, the next day, Morales. Hi, Steph, it's David Fleischer. Hey, are you here tomorrow or Friday? Right, do you mind, can we do it tomorrow? Yeah, he's picked up a new case and we need to do bond condition. Yeah, sorry, we were in trial today and it was just really hectic, but. That's okay. Are you okay tomorrow? Okay. Got it. But I don't know, I need to know what else, if anything. And, so we'll put him on for tomorrow. Hey, I'm gonna be a little bit late tomorrow because I have to do something. But if you want to maybe pop in like 10:30. Okay? Okay. All right, thanks. All right, take care.
The R word on the record. Yesterday, he kept calling her mentally.
Yeah.
Really? I guess, I thought I heard, but.
No, he did say it yesterday. I looked.
R.
Just for the record.
Oh, I'm talking about Morales R. Hey, Morales R. I guess she sent him on the way.
I know, I said last thing.
Is he out there?
I don't know if he's out there now.
Okay, hey, can we roll until tomorrow? I spoke to Steph, she's okay.
Yeah. She said, okay.
Yeah. I don't know.
She said she don't have that. There's an R and there's Morales J. Morales J.
I just needed to know they should be back to the Did you see?
Oh, I don't even see Morales J.
He's on page 44, Judge.
Okay. Yes, this is the guy that I'm talking about. That's not, there's no J. That's Rafa. That's right. This is Stephanie's client.
It's two different spin numbers.
Yeah, that person over there is not Rafael Morales.
Yeah, it doesn't look like him. That's not the one I'm talking about. That's, do you have a lawyer?
I don't know who that is.
Do you have a case on the docket today?
His lawyer is.
What's the spin that you got?
What's his name?
Or do you have a cause number maybe?
Yes,
What is it?
it's 2613855.
I know I saw Christian here earlier.
Yeah, he was there. Yeah, you got the case with me, Judge. I don't know why.
Yeah. Do you want to maybe just give Mr. Morales a copy and we'll send him on his way?
Come on up, Mr. Morales.
Come on, we'll send you, your lawyer was here early and reset the case, but did you not talk to him? Okay, we'll give you the new reset date and we'll send you on your way. Okay? Sorry, you'll have to reach out to him. I can't talk to you without your lawyer. But we'll just give you the new date if you want to reach out to him.
Absolutely.
They have a verdict.
You have their. Oh, you could say, yeah. It's hard for the.
What'd you say?
They have a verdict.
Yeah, hey, they have a verdict.
Well, two of them in the restroom right now, so they give a few seconds.
Sure, I get it, verdict, yeah.
I didn't read it.
Hey, they have a verdict.
No one ever does.
Nobody.
Come on up. All right, bye.
Okay, it looks like that. No. True. They weren't just filling their thumbs to the verdict back there.
Yeah, I just let him know.
Oh, yeah.
Yeah.
Who? Will you?
No, he's telling her.
So where'd you go? Where are you in Guelph now? How's it going?
It's good.
Yeah.
I like it.
You spent still so much time with us that, you know, you're home away from home. Yeah.
I've been here more than.
We're happy to have you. Dang, see, that's a kick in the ding ding.
I thought it was a horrible day.
Right, see, she moved to 12. Court trial, wow. But you guys agreed to the court trial. Oh, that's cool. Yeah, I think I've only done one.
No, it's much simpler.
Thank you for the help.
Yes, sir. Everybody's here?
Are you guys ready to bring the jury in?
Yes, right.
Okay, let's go. Yeah, for sure. Hey, anyone you want to talk about?
That was the last one.
But no FTAs or anything?
No. Oh, sorry, Judge, page 25, central arraignment, vote to appear.
Bottom or both?
Bottom,
2501. We didn't do the top up. Is that on air?
the bond report says 714. Oh, Judge, page 29. All over is the
Mm-mm.
defendant didn't show up today.
Okay, 5001. Or, yeah, 5001 on both. He was due here, right? Okay. On both?
Yes, Judge.
Yeah, 5001.
And then page 28, Wilson was a required appearance and didn't show up.
Oh, she called in. She was on Zoom. She took off. And then Daniel came in right after. And by the time I got to him, he had left too. So give me 5 minutes and I'll call them.
But for Watson, you didn't revoke those bonds, right? Watson, the one that was taken in on the felony over. I don't think you did. The probation that you revoked?
I have the motion to like you, Judge, but I don't know if you want me to make jury.
Okay, Your Honor, for Wilson, I'm filing a dismissal.
Oh, great.
All rise for the jury.
All right, you may be seated. Ladies and gentlemen of the jury, Mr. Foreman, have you guys reached a verdict?
Yes, we have, Your Honor.
Is it unanimous?
It is.
Okay, if you'd like to hand to the bailiff. I will read it to, in cause number 256-5785, the state of Texas versus Jaime Cruz, we find the defendant not guilty. Okay, this is all your verdict, correct? Okay, you guys may be seated. And that concludes your jury service for now. If you'd like to retire to the jury room, I'll be there shortly to talk with you guys, okay? Please.
All rise for the jury.
Oh, he signed it, okay. Yeah, we're good, thanks. Okay, that concludes it. All right, can we go back to the box then? You guys want to wait, you can talk to them as well. Just let me say hi to Mike real quick.
Is Mr. Cruz, you want to stay around?
No, it's pretty good. He's pretty good.
Can you sign the motion then?
Thank you. I got it. Is it
It's something where they call it about employment and then they're like,
Can you
oh,
just think about it?
like an employee. I used to get them at work and we could only run them up on, I forget what the link was.
You know what, I'll take it. I'll take it. A couple. Oh, just one. But if you want me to. Yeah. Okay. Oh, yes. I'll stick around.
I can even.
It doesn't, I think she's on the. I think she's.
Yeah.
It's just a picture.
Oh, maybe she's not. No. Oh, yeah, there it is.
Yes.
Yeah, I'll just email her.
Okay.
Sorry.
You came through. Okay, perfect. Anything else?
Hopefully not.
Should we, is anything else?
Okay. Could you just get with it?
Yeah. The judgment wants to give signs of let's say, or they're. Yeah. Thank you. He's good to go. I don't need a first.
Oh.
Okay.
I do. I was just clicking. Bye, see you tomorrow, maybe. No, you baby. This was it. It was the other way around. I didn't even have one, so I don't think it's 50,000.
I've seen it the other way. Back to back. That was funny. Kept laughing. At first I was gonna hold it, I'm just like, oh, hell no. It was really, I could feel it through whenever they start talking to everybody. Yeah, and I'm like. Just like. Oh, guys. I know, people taste it. No, I wouldn't. I just, the only question. Yeah. Just. No, I'll just, the only thing I'll say. Advice.
We still need your service. This is great.
It's all the stuff, look at their eyes, so, yeah, that's what I can see.
And wins.
And then, no, when you said it, that's what I learned. I thought it was each section, like, and then I read it. You could get it out. You could hold it. Oh, yeah. No, because that was got changed. Because I was looking at
You know. Well,
okay,
Hey, you earned your pay today, huh?
I'll give you a little bit.
Man,
Yeah.
well, good job.
Thanks, Jared. Judge?
No, I know, I gotta sign the judgment and, yeah.
Like, please don't. And, what are you setting that imaging to?
What's in it now?
2505. Picked up two new parties.
Yeah, 10,006, please. What'd you say?
I said 50,000.
Really? Dang.
It should be 100,000.
I said.
All right, let me